it's original side, please mention.
My lord, appellate side.
Mention. For inclusion,
Yes, my lord.
hand over the slip.
My lord, rest
All the slips, please hand over all the slips in the original side.
This is
Appellate side, please come back at 2. When I take up the appellate side.
Lord, may I have your lordship's kind leave to mention
Yes.
some amount of trepidation in my heart.
Why?
This was a Section 11 application, my lord, where I had sought for filing opposition. My lord, I went through the petition. I really don't think, my lord, I should file an opposition. Lordship can, even though, my lord, liberty had been granted to file the opposition, but to expedite matters, my lord, I thought I should mention. Lordship may kindly appoint an arbitrator of your lordship's choice on the claim and the counter claim, my lord. I've
So
served notice
This
on
is
my-
not in the list today, obviously.
No.
I appear for the petition, my lord.
So let me, this will appear tomorrow in the list.
In that event, could it be day after, my lord?
Day
Tomorrow,
after, yes, why
I'm
not?
very grateful.
Day after tomorrow it will appear.
I'm extremely grateful.
And please just remind me, Mr. Mitra, so that I can record that you are not willing to use an affidavit in opposition to expedite the matter.
Certainly.
I'll record that and
certainly.
pass by.
Lordship,
Grateful.
I'm very grateful.
Thank you.
May I be permitted to mention a matter which is not in lordship's list?
Appellate side matter.
Appellate side matter.
Appellate side, please mention at 2 p.m. When I take up the appellate side, my officers will be there. Please mention them.
Item number 1. Suresh Detective and Securities Private Limited.
May it please, my lord, I appear for item number 1 and 2 for the petitioner, my lord.
Yes.
On the last occasion, my lord, your lordship has directed us to serve the petition. We have served it by way of an email.
Not received. Somebody was appearing for them.
Yes, my lord. My lord, kindly,
I'll pass it over in the first call.
my lord, kindly then keep it not today, my lord,
Why?
because I'll have to go somewhere else.
Very. None appears for the respondent at the time of call. First of the receipt of service filed in court today be kept on record. Let the matter stand over for the day.
I'm much obliged.
Item number 2.
My lord, same order may be passed.
Same order. But these email things,
Yes, my
if
lord.
you produce printouts of the emails,
Yes, my
then
lord.
you should better use a supplementary affidavit on the next occasion. I think that will be
I
better
shall, my
because
lord.
somebody else is sending it. I mean,
My
whoever
lord,
is,
my advocate on record is sending.
but she has to say it. I mean,
Very
your
well.
clerk has to say it.
Very well, my lord. We shall see. I'm much obliged.
Thank
Item number 3. RSM Constructions versus Texmaco.
Pass over in the first call.
Item number 4. RSM Constructions Texmaco.
Same.
Item number 5. Godrej and Boys MFG Company Limited.
Please,
versus
on behalf of
Respondent.
on behalf of the applicant, praying for short passover.
Pass over. Pass over in the first call.
Item number 6. ACPC Limited versus Hindustan Copper.
Same. Pass
Item
over.
number 7. Tata Capital Financial Services Limited
Your
versus
Lordship, this is
Krishna
my
Automobiles.
section 11 application.
Have you served properly on the other
Yes,
side?
yes, Your Lordship, I have served. They have received my application.
Let me pass it over in the first call because somebody may be appearing. So first call pass over, second call I'll take up.
Item number 8. Surjo Politics Private
Appear
Limited.
for the petitioner, my lord. The affidavit of service has been returned as the absent. We have,
Absent is
yes,
not-
my lord. The difficulty is I have served it on the address that is known to me and on the letterhead as well as by email.
The absent is virtually not claimed. I mean,
That is the difficulty. It does not amount to service, may not amount to service
not amount
also.
to service. So serve afresh,
I can serve.
take another chance, we'll see
Very
what
good,
happens.
very
You file this affidavit in the, of service. The affidavit order, the affidavit of service filed in court today indicates that proper service has not yet been effected on the respondent, comma, since the envelope sent has come back as come back with the endorsement within double inverted absent, double inverted close, stop. Hence, the petitioner is directed to serve a copy of the application afresh on the respondent, indicating that the matter shall be listed on May 15. I'm giving you a fortnight's time.
Grateful.
May 15, 2023, when the petitioner shall file a fresh affidavit of service to that effect.
Now, this is not even a company that I can serve it on their MCA
Please,
website. That I could have served it on MCA portal also, but it's not a company. That is the difficulty.
Take your chance by other
I'll
portal
try.
also if you can,
I'll
if you
try
have
and-
the email and put everything in the affidavit of service.
Grateful.
And if you can show me something that they had given their address as this, some document, then also I'll consider that on the next occasion.
Very
But I'll
well.
give
It
them
is
one
on
chance.
The arbitration agreement, in fact, my lord, has signed on their letterhead.
Very well, that can be one of the ground. Try another time.
I'll try.
We
I'll
will
try and
come
come.
back. Yes.
Grateful.
Item number 9, Srimati Shumani
Your lordship,
Kumar.
I'm praying for a short pass over.
Pass over. First call.
Item number 10, Oscar Industries Private Limited versus Union of India.
Pass over in the first call.
Adjourn motion. Item number 11, West Bengal Power Development Corporation Limited.
Same.
Item number 12, Ritik Bhattacharya and another versus Mr. Sanjeevani Diagnostic and Healthcare Private Limited.
Pass over in the first call. That was second call.
Item number 3, Passover matter. RSM Constructions.
None appears for the petitioner at the time of call. Full stop. As a last chance to the petitioner, the matter is adjourned for the day.
Item number 4,
Same order.
item number 5,
Lordship, I appeal to the petitioner. I'm seeking a week's time, extension of time for filing my reply affidavit.
May I kindly hand over the affidavit in opposition in this service?
Affidavit in opposition filed today be kept on record. Full stop. On the prayer of learned counsel for the petitioner, the time for filing affidavit in reply is extended for a week from date. The matter shall next be listed on May 8, 2023.
I'm deeply obliged.
Grateful, Lordship.
item number 6.
Your lordship, I
SCPC
appear for the
Limited.
respondent.
Respondent,
Respondent if the petitioner isn't present.
you are in the next matter. None appears for the petitioner, although the respondent is represented through counsel. Full stop. As a last chance to the petitioner. None appears for the petitioner, comma, although the respondent is represented through counsel. Full stop. As a last chance to the petitioner, the matter is adjourned for the day. If you can, please intimate the learned advocate for the petitioner. This is the last chance I've given. Otherwise, I'll dismiss for default.
Yes, your lordship. Grateful.
Item number 7,
Yes.
Tata Capital Financial.
Good service, you said.
Yes, Your
Hand over.
Lordship.
Yes.
Your Lordship, this is my section 11 application. The first loan agreement was sanctioned on 13th August 2016,
Mhm.
which is at page number 27, Your Lordship.
Mhm.
After that, the loan agreement has been renewed several times. They lastly renewed on by the sanction letter dated 30th August 2021, and the agreement dated 7th September
Give me
2020.
the page number.
Yes, Your Lordship. Page number of
High
the sanction letter is 101, Your Lordship. And my agreement starts from page number 116.
Yes.
Your Lordship will find the arbitration clause
Right.
is in the page number 118, clause 12, Your Lordship, at the bottom. If any dispute, difference, or claim arises between any of the obligors and the lenders in connection with the facility or as to the interpretation, validity, implementation, or effect of the facility documents.
What is the nature of the dispute you have raised?
It's a commercial, it is a working capital finance loan agreement. We have sanctioned a amount of rupees 1.95 crores for their
Yes.
business.
Hmm.
And nothing has been guaranteed to us. This is a channel finance agreement.
Very well. Now, show me the invocation letter.
Invocation letter is, Your Lordship, at page number 132. Our claim of rupees 1.39 crores. And my section 21 notice is at page 143, Your Lordship will find, and it has also been delivered. My track report is also annexed with the petition, Your Lordship. Section 21 track reports.
Should he be an former judge of this court? The arbitrator?
Yes, Your
I think
Lordship.
that will be better.
Yes, Your Lordship.
একটা order.
Appearance.
Despite service, none appears for the respondent. Full stop. The affidavit of service filed today be kept on record. Stop. The petitioner seeks a reference to arbitration. Full stop. An invocation under section 21 of the Arbitration and Conciliation Act 1996 finds place as Annexure E at page 132 of the present application under section 11, comma, dated February 17, 2023. Full stop. as averred in the application, comma, there was no response on the part of the respondent to such invocation. Full stop. It is evident from the documents annexed to the present application that from time to time, comma, there was a finance loan agreement entered into between the parties. Full stop. The last such agreement was dated
7th September, Your Lordship.
7th September.
September 2021.
Was dated September 7. September 7.
Yes, Your Lordship.
September 7, right? September 7,
2021.
2021. Full stop. In clause 12 of the said agreement, comma, there is a provision for arbitration which which covers the dispute now arisen between the parties. Full stop. Hence, comma, AP number 164 of 2023 is allowed, comma, thereby appointing Justice Muhammad Mumtaz Khan, a former judge of this court, as the sole arbitrator to resolve the dispute between the parties, comma, subject to obtaining a consent stroke declaration under section 12 of the 1996 Act.
Grateful, Your Lordship.
Item number 9, pass over matter. Srimati Shumani
Yes,
Kumar
Your
and
Lordship, this
another.
is my application, Your Lordship.
Yes.
Your Lordship, the short point is it's arising out of a partnership.
You are for the respondent.
No.
With him. What about service?
The service, Your Lordship, it's a good service. It has been refused by, this is the affidavit of service, Your Lordship.
Yes.
The respondent number 1, it's saying that addressee not found.
Yes.
Addressee is not found. And in respect of respondent number 3 to 4, they have refused it, Your Lordship. Even the section 11 application, when we served it, it has also been refused. My lord, I'm beseeching Your Lordship to the deed of partnership at page number 23, Your
So
Lordship.
they are all as partners.
Yes, they're all as partners, Your Lordship.
Page.
Kindly comes to page number 23, the partnership deed, Your Lordship. The relevant pages, paragraphs are 17 and 18 at page 29, Your Lordship. The arbitration clause is at paragraph 17, Your Lordship, that in course of partnership with regards to the management, supervision, or in any other issue, if any, dispute arises by and between the partners. In that situation, the partners shall settle settle the said dispute through their appointed nominated arbitrator. But in case if
Very good. Show me your invocation letter.
yes, Your Lordship, it's at page number 66, Your Lordship. Your Lordship, we had suggested one name of Mr. Murari Chakraborty, Your Lordship. It's at page number 66. The relevant portion is at page 67, Your Lordship.
This was received by all of them.
Refused, Your Lordship. This was even also refused.
One also refused in this case.
The first one, addressee not found. Now, Your Lordship, may I indicate one thing, Your Lordship?
Addressee not found is, I mean, the
No,
first
no,
partner can come up and file a recall application.
No, Your Lordship, may I hand over the,
The deed mentioned, no, that is the address of the partnership
yes,
firm.
Your Lordship. Kindly seize, Your Lordship, these are the returned consignments.
No, you are not ready with an affidavit of service.
No, no, I have served it. This is the section 11
Oh,
notice. This is the section 11 notice which was written.
Section
which is-
21 notice.
Section 11, appointment of the arbitrator, Your Lordship, because in the arbitrator is not named in the
The
partition.
Section 11 application you have filed.
Yes, Your
Now
Lordship.
you tried to serve this. Now
Return.
regarding that you have filed this affidavit of service.
Yes, regarding the section 11 application.
Yes,
As
that
per-
will be the section 21 notice then. Section 21 is the commencement of arbitration, not section 11.
Section 21 is the commencement of the arbitration.
That is regarding section 21.
Yes, this is regarding the section 21.
You are saying section 11, that's why I asked.
I'm sorry, Your Lordship.
So it must be the invocation of the arbitration.
Yes, this must be the invocation of the arbitration.
So I'll take those on record also.
Definitely, Your Lordship.
So the fate was same for them.
The
The
fate
first
was
one, not found and
Not found. Same, it's the same fate.
what is the nature of the dispute?
The nature of the dispute is, Your Lordship, the partnership deed is this. The petitioners are the daughter of the partner 1. Now, she had expired in the year 2021, Your Lordship. Now, in respect of paragraph number 18 of the partnership deed, Your Lordship, it says that in course, kindly comes to page number 29, Your Lordship, in the paragraph number 18, that in course of partnership, if any partner dies, in that event, his or her legal heirs shall be automatically partners of the Sudhamuni Memorial School, Your Lordship, and all the benefits with other partners. But this clause shall not be applicable for the partner number 5. Your Lordship, there was a mutually understanding between the partners that the partner number 5 will not be included in
You are
this.
not the heir of partner
No,
number 5.
I'm the partner number 1.
But the difficulty is, because clause 17 says in course of partnership with regards to the management, such and such, if there is a dispute arising by and between the partners in that situation, you are still not a partner.
I have made representations, Your Lordship, to include me as a partner, but they have not. Kindly comes to the
Then
notices.
you are
which
not a
have-
partner still.
Still now, but I'm in
Question is regarding partners only.
partners regarding that, my lord,
There is
the
some
dispute.
doubt. Some doubt.
Then may I come back?
Where is your invocation notice? Let us see that. You gave me the page number.
Yes, it's on page number 66, Your Lordship.
66, right? There is some doubt for the partnership, whether the clause contemplates partnership between a third party and because you want to be a partner
Yes, Your
and you
Lordship.
stake a claim, definitely have a right to do
Yes.
that.
As per the clause number 18, Your
But
Lordship.
this says in course of partnership specifically says the partners dispute arises by and between the partners. In that situation, the partners shall settle the said dispute. You are still not a partner.
Yes, Your Lordship, but
Your dispute is regarding 18.
yes, my dispute
So
is
whether you
regarding-
will become a partner or not,
My lord, as per the paragraph number 18, Your Lordship, I automatically become the partner, Your Lordship. Because it says, it categorically says, shall be automatically partners.
yes. Very well. Keeping this question open, I'll refer it to arbitration. What is the valuation?
Valuation is just, I do not know, very meager amount, not very.
Very well. Ashwin. Affidavit of service filed today be kept on record. The envelopes please file in court.
Yes, Your
the
Lordship.
section 20. Affidavit of service filed in court today be kept on record. First of it transpires that the envelopes sent to respondent numbers 2 to 4 have returned with the endorsement refused, comma, which amounts to good service. Full stop. However, comma, the intimation given to respondent number 1 has returned with the endorsement not found. Full stop. Next para. Although there is some doubt as regards whether the service of notice on the first respondent has been completed, comma, it is submitted by learned counsel for the petitioner that even at the stage of service of the notice of invocation of arbitration under section 21 of the Arbitration and Conciliation Act 1996, comma, the attempted service to the respondents suffered from the same fate. Full stop. The envelopes containing the notice under section 21, comma, filed today be kept on record. Full stop. Next para. Hence, it transpires that since the respondents have been impleaded in the capacity of partners of a partnership firm, comma, substantial service has been effected on the respondent. Full stop, next para. It is seen from clause 17 of the deed of partnership dated June 29, 2019, that the petitioner's predecessor in interest was one of the partners. Full stop, clause 18 of the same clearly stipulates that in course of partnership, if any partner dies, in that event, his stroke her legal heirs shall be within double inverted automatically, double inverted clause, partners of the firm and with all the benefits of the other partners. Full stop, next para. Hence, comma, it is arguable as to whether the petitioner has, comma, by operation of the said clause, comma, automatically become a partner and, comma, as such, comma, comes within the ambit of, within double inverted partners, double inverted clause, as used in clause 17, comma, which is the arbitration clause. Full stop, clause 17 provides that in course of partnership with regards to the management, comma, supervision, comma, or in any other issue, if any dispute arises by and between the partners, in that situation, the partners shall settle the dispute through their appointed stroke nominated arbitrator. Full stop. In case of failure to settle such dispute, the partners would be at liberty to take shelter in the court. Full stop, next para. In view of the above discussions, comma, the petitioner has made out a prima facie case that the petitioner has automatically become one of the partners of the firm, comma, although such question is required to be conclusively decided only by the arbitrator when the matter is referred to the to an arbitrator. Full stop. Next para. Hence, AP number.
Lordship, may I just take 1 minute? Lordship?
Accept. Yes.
Lordship, as far as section 40 of the Arbitration and Conciliation Act is concerned, where one of the parties dies, one of the parties to an arbitration, automatically the legal heirs will be brought on record.
That is there.
Yes.
That is there. But the language clause 17 is
Yes.
some of the partners, they are entering into that, the existing partners they're entering, and in one of the other places of your agreement, existing partners have, in your invocation,
Yes.
existing partners has been used.
Yes.
So there may be a distinction between existing partners who entered into that clause if there is a dispute between the partners.
Yes, my lord.
Whether you have become a partner or not at the outset, you are facing an obstacle.
That's as per the agreement.
And that
it
is
says
the
we have-
dispute. That's why I have kept this open.
Very,
Mr.
very,
Kaur.
very, very, Lordship.
But your learned junior argued very competently. Whatever you argued, he did argue, I mean, in a different way. AP number 228 of 2023 is allowed, comma, thereby appointing Mr. Tanmoy Mukherjee, an advocate practicing in this court, as the sole arbitrator to resolve the dispute between the parties, subject to obtaining declarations to consent under section 12 of the Arbitration and Conciliation Act 1996. Mr. Kaur, in view of the quantum involved, Mr. Mukherjee is an
Lordship,
advocate.
can follow the schedule 4.
We'll have to follow the schedule, yes.
আমি একটা জিনিস ইন্ডিকেট করতে চাই ইনভোকেশনটা অ্যাকসেপ্ট করেছি সেকশন 11
হ্যাঁ কোডটা কি আছে ওই শুধু রেখে দিন ওটা না হলেও চলতো কিন্তু নেই তো ওরা ওটা অ্যাডিশনাল কিন্তু রেখে দিন এগুলো রেকর্ডে যা দিয়েছে থ্যাংক ইউ
I'm grateful, Your Lordship.
Item number 10. Mrs. Oscorp Industries Private Limited
Yes,
versus
Mr.
Union of
Banerjee.
India.
My application has come back again after the other side did not appear despite service. My lord had given them one further opportunity. None appears.
Move the matter.
Volkswagens were to be,
No, good service was effected previously.
yes, earlier, my lord, good service was
We
effected.
had filed the affidavit, sir.
We had filed the affidavit of service. My lord had given them one further chance.
Right.
Volkswagens are supposed to be repaired by me. That's the
Box-
contract.
box.
Volkswagens.
I thought the car.
Oh.
Folks, yes. Yes.
So, my lord, kindly come to page 26, Annexure D. That's the contract. The contract says that the general conditions of contract would apply. Now, I say that I have obtained 2 extensions without payment of liquidated damages clause. The third extension, I was compelled to apply for liquidated damages. They gave me,
Southeastern Railway is not coming up.
it's not coming up.
Despite service.
Surprising.
Do you know who is appearing? Because they would positively take a point that it has to be from their panel, and when you will say that they're ineligible on that.
Yes, because
In every matter that is taken. So let them take that point. Otherwise, they'll just have a recall application and have the order recalled. It will be a futile exercise, Mr. Banerjee.
If your lordship wants,
Do you have any idea who are the? I mean, is there any office of the South? Can you serve directly on the office, indicating that the matter is appearing on 2 occasions they did not appear?
I can also serve on
Yes.
the advocate on record of the Union of India. In one
Very
way, that will also help.
Very well. I'll put that in my order. I'll keep it next week, Mr. Banerjee. Let us take a last chance. If that fails also, you'll file that receipt and I'll take up the matter. Because this has to be otherwise referred.
Yes, yes.
This is the second occasion when, despite service, none appears for the respondent, full stop. The petitioner shall serve a further notice to the respondent as well as as well as a learned advocate from the panel of the Government of India, Union of India, indicating that the matter shall next be listed on May 8, 2023 for hearing. Full stop. A receipt to that effect shall be filed on the next date by the petitioner. Let us see.
My lord, advocate on record of the Union of India, if it please to your lordship, because in the panel there will be many.
From the panel na kore, learned advocate on record.
Learned advocate on record of the Union of India.
learned
That's
advocate on
Strand
record
Road
of the
office. where we
Union
can
of
serve.
India. Very well. And Mr. Banerjee, you also come prepared on their points if they don't appear.
Yes, yes. Their points will be one of territorial jurisdiction, which I can meet.
You will also have to meet those points.
I can meet.
Adjourn motion, item number 11,
Yes, 11.
Passover matter.
11 is by.
Item 11.
11, yes.
Learned advocate of the petitioner lordship, he is sick. So for not this week.
Yes, become.
What's
11,
11.
original side.
original
Yes,
side?
recovered.
Original side?
Original side, monthly list.
Original side?
No, you're probably mentioning a.
Advocate on Gaur Chandra Manna.
No, it's not.
11
that.
of Amadev.
Yes.
It's West Bengal Power Development Corporation Limited.
This is a.
Yes.
It's the section 11 application. I don't think there's any. So there's a dispute regarding the arbitration covered by arbitration. Not in fact, we had invoked the arbitration clause by which we asked our appointing authority, the PDCLs, to appoint an arbitrator. He started, they moved section 14, removed. Then we moved a section 11 application. The division bench felt that, the Honorable Chief Justice felt that there has to be a section 11.6 notice first before we can invoke. So on that line, Lordship will kindly see the last order of the Honorable Chief Justice is at page 413, third volume of the petition. Yes. So 21 notice.
That was the objection taken by them. Actually.
That was section 14 stage. Then came the section 11.6 application. There was no notice to 21(11), nominating an arbitrator and asking them to appoint. So that was the second objection. Now that's been taken care of. We nominated an arbitrator. They did not agree. And we are before your lordship.
So section 21 was not complied with.
Yes.
That has been complied with.
That has been complied.
That has been annexed here.
Yes. The next page.
Yes.
Next page, we nominated
Well, any objection, serious objection? What is the serious objection? Yes.
First objection was your lordship.
Take the microphone, please.
First
Samita, take your
objection
seat. I'll just take it, please.
was that the application under section 11, the certified or copy or the original of the agreement was not annexed. But I'm just filing my affidavit in opposition. Those directions.
So your lordship had told me to take the point in the affidavit in opposition, and I had relied on the scheme framed by the Honorable Chief Justice of this Honorable Court, which says that it is mandatory. Clause
Mandatory?
3A says that an application has to be filed along
Has to
with.
be.
Kindly.
What is the effect in in clause 7?
My lord, the effect is because this scheme has statutory force under section
it has.
11 subsection 10.
We are proceeding on the premise, it's a statute.
No, but I'll tell your lordship in their reply, I find that they have now annexed a certified copy. Now your lordship will consider if that is sufficient compliance, I'll not take that objection. Now your lordship, the second objection was this. This was a tender, your lordship. The bidder was one, Sickle Logistics Limited. Now this was the successful bidder. There was a provision in the agreement, the letter of award which was given to them at page 84 of volume 1
Of
the affidavit in opposition. Huh.
84.
Your lordship's clause 7.21.3.
Hmm.
So in case the selected bidder is a consortium, within 30 days of issuance of letter of award, the bidder shall form a SPV company incorporated under the applicable Indian laws. The authorized signatory of each consortium member shall also sign the coal mining agreement and shall remain jointly and severally bound by the terms and conditions of the coal mining agreement and shall be responsible and liable to WBPDCL for the performance of all contractual obligations throughout the contract period as if it were individually the mine developer and operator. Now, your lordship, the bidder was not a consortium, but they made a request for formation of a SPV. So the respondent before your lordship is a SPV, special purpose vehicle, specifically formed for giving effect to this project by the principal, which was Sickle Logistics Limited. Lordship will find this from the correspondence which we have annexed between the companies, that in terms of this provision, they were appointed.
No, it is the SPV itself which came up on the last occasion also.
Yes, your lordship. Now what happened?
That chapter is closed.
Because, my lord, they are joint and several liability. The main company, Sickle Logistics Limited, went into insolvency, the corporate insolvency resolution process. There was a resolution plan which I have annexed.
Can I go into this?
Your lordship, because it wipes off all liabilities specifically under this contract. That clause I'll show in the resolution plan. And
At
your
best
lordship,
section 16.
judgment.
At best section 16. Arbitration Act.
Then your lordship
I'll
keeps
keep
the
that question
question open whether there is no life claim at all because of the wiping off of the liability. It specifically mentions this contract with the date of this contract and says that all liability under this contract shall be extinguished. And they had the opportunity to file their claims. Your lordship knows all creditors are invited to file their claims.
Show me that clause.
They did not.
Have you annexed it to your opposition?
Yes, your lordship.
Show me that only.
It's in volume 2, your lordship.
Volume
Just
2.
place the relevant. Resolution plan. Volume 2 to where is the lordship, the resolution plan starts at 156.
So can I record that your argument is as per the resolution plan, the by operation of the clauses of the resolution plan, this agreement itself has been wiped out. This much will do. I mean, I won't go into the merits of
Yes, your lordship.
Mr. Mitra, I'll keep that question open for
So it cannot be, but then the law is very clear, but then let me not argue. Since he has not argued, why should
No, Mr. Mitra, I'll record. Obviously, we're refuting that very well, at order. The petitioner previously had an appointment of arbitrator, who was subsequently removed under Section 14 of the Arbitration and Conciliation Act 1996 at the behest of the respondent. First up, upon a subsequent application under Section 11 of the 1996 Act having been filed, previously the petitioner had been directed to return after compliance of Section 21 of the said Act. First up, subsequently such compliance has been effected, and the present application has been taken out for appointment of an arbitrator in view of the arbitrator having not been settled or agreed between the parties. Full stop, next para, learned counsel appearing for the respondent opposes the prayer for reference to arbitration on the ground that the agreement containing the arbitration clause itself has been wiped out by operation of the clauses of the resolution plan entered into in connection with the matter. Full stop, next para, such argument is, of course, refuted by the learned senior advocate appearing for the petitioner. Full stop, be that as it may, since the issue is definitely arbitrable and falls within the purview of the arbitration clause, the dispute sought to be raised by the respondent enters into the domain of the of arguability, which is a component of the dispute raised between the parties. Full stop, as such, it would not be prudent within the limited jurisdiction of this court under the contemplation of section 11 within bracket 6 capital A of the 1996 Act. Full stop, accordingly, the said question is required to be left open for being decided by the arbitrator along with the other issues involved. Full stop, hence AP 28 of 2023. What will be the valuation of the dispute? Since Mr.
209
Mitra is
crores
there,
the claim. 209 crores is the claim, and certainly if your lordship jurisdiction point is not acceptable, we'll have a counter claim for your lordship.
It will be substantial, but then ultimately it will not be verified. But then the claim will be lot.
Should I appoint Justice Indira Banerjee in this matter?
Her ladyship is doing one arbitration. It's nothing.
Because
she's coming down from Delhi and spending a few days and going back. This is because she's based in Delhi. So that way, it's a bit logistical issue is there. So in fact, I have one on Thursday before her ladyship.
I also have on Thursday.
So it's because she does
both of you have, so I'll appoint her.
2 shifts, 5 o'clock.
You're the Power Development Corporation.
But financial is a problem, but then only getting the dates will be a little of a problem.
No, no, she's already. I mean, there are several arbitrators.
Several arbitrations, but then she's knowing her. She's very. She already has 17 arbitrations appointed by.
16 arbitrations, and she's coming for 2-3 days every month to do.
Or even a High Court judge, retired High Court judge,
I think
or a Chief Justice, retired High Court.
Chief Justices are all. I mean, engaged in other offices.
One Chief Justice name, your lordship possibly have difficulty suggesting.
Yes, that is a
can.
difficulty. And there are specific directions not to appoint him by him.
No,
so definitely I'll not appoint him, obviously. So Justice Jyotirmoy Bhattacharya is in the Human Rights Commission, but he probably is of the opinion that there is no bar in taking up.
No. I am doing 2 arbitrations before him.
Very well. Then I'll appoint Justice Jyotirmoy Bhattacharya. By appointing Justice Jyotirmoy Bhattacharya, a former Chief Justice of this court, as the sole arbitrator to resolve the dispute between the parties, subject to obtaining consent stroke declaration under Section 12 of the Arbitration and Conciliation Act 1996.
I'm grateful.
আরেকটা লাইন অ্যাড করে দিন।
My reply is kept on record.
Very well. আচ্ছা, প্রথমে একটা দিয়ে দেবেন affidavit in opposition and affidavit in reply filed to be kept on record, এটা প্রথমে দিয়ে দেবেন। আর লাস্টে একটা লাইন অ্যাড করে দেবেন, it is reiterated that all issues, including the issue as regards whether the arbitration, the agreement itself has been wiped out by operation of the resolution plan, are kept open for being decided by the arbitrator.
I'm grateful.
Item number 12, Hrithik Bhattacharya and another versus Mr. Sanjeevan Diagnostic Center.
12, I appear for the petitioner, Your Lordship.
My lord, on the
Last occasion, my lord, the respondents appeared and my lord.
You are appearing, Mr. Thakur?
Yes, my lord. Directions were taken for filing affidavits, but
Acha.
after that, there's been a change of the counsel, my lord, and the advocates on record. So, my lord, I was praying for some
You
time.
still intend to file an affidavit
Yes,
after
yes,
going
yes.
through the records?
Yes, there is a serious issue, my lord.
So when should I, how long?
Kindly, my lord, kindly give me a fortnight to file, my lord. There are three respondents, three sets of respondents.
On the prayer of learned counsel for the respondents, the time for filing affidavit in opposition is extended till May 18, 2023. Full-stop reply, if any, shall be filed by June 9, 2023. The matter will be listed for hearing on June 12, 2023.
Very good.
Grateful, my lord.
Deeply obliged.
অনেকগুলো হয়ে যাচ্ছে। অনেকগুলো হয়ে যাচ্ছে। ঠিক, appellate side.
May I be permitted to mention one?
Appellate side matters?
Yes, madam.
Yes, you can mention now also at 2 PM also, yes.
My
What
lord,
is the
it's a listed.
appellate side for inclusion?
Yes, my lord.
Please mention.
My lord, it's a listed motion, my lord, for inclusion in a lordship's list, my lord.
Electricity matter?
No, not electricity matter.
Then I don't have determination.
It's a not electricity matter, my lord.
Which year?
It is of 2023.
No, I don't have determination. File before the, mention before the appropriate court. Appellate side, any mentioning, any other mentioning?
Lord.
Yes. What do you want to mention?
Well, for enlisting the matter,
Hand over a slip, yes, included.
subject to lots of convenience for enlisting.
Yes, yes, hand over a slip. It will be included. Slipটা একটু দিতে বলো, বুঝতে পারি। ঠিক আছে, লিস্টে দিয়ে দিও তাহলে। ভেরি গুড, ইট উইল অ্যাপিয়ার ইন লিস্ট।
Appellate side, new motion item number 1.
Yes, your
Yes.
lordship, I am appearing for the petitioner. My lord, on the last occasion, your lordship has been pleased to, my lord, restore the application which was dismissed for default on 3rd of April and was further pleased to give us liberty, my lord, to add, my lord, WBSCDSL, who is also a necessary party, and to serve. My lord, service has been done, my lord.
Completed?
Yes, completed.
What
Now,
is the
my lord,
matter?
So
Yes.
far the matter is concerned, my lord, this is a change brief although, my lord, what I find, my lord, if your lordship kindly take the trouble, my lord, to come to page 46. My lord, pole has been erected in my land. I made a complaint before the WBSCDSL. Now their divisional manager, my lord, informed me at page 46 that, may I place, my lord? Page 46, with reference to the above subject matter, the undersigned would like to inform that the erection of the said works is being done from National Highway Division, number 2 Public Works Road Directorate. Hence, thus you are being requested to kindly contact the concerned department. That is their answer. So thereafter, representation was sent through advocate also at page 48. So, my lord, it can be subject to correction, disposed of by directing them, my lord, to consider in accordance with law.
You're directing which respondent, Mr.
My lord, so far, my lord, it will be PWD, my lord,
Highway Division?
divisional engineer.
Oh, PWD is doing it?
Yes, according to the electricity board. They inform at page 46.
PWD?
That is the difficulty.
Oh, acha, yes, yes.
Yes, yes.
Maybe.
So, my lord,
Very well, I'll dispose of the writ petition. by
Yes,
saying,
my lord.
Despite service, none appears for the WBACTCL at the time of call. Stop. The affidavit of service filed to be kept on record. Full stop. Learned counsel for the petitioner places reliance on annexure P3 at page 46 of the writ petition, which is a communication dated December 20, 2017, made by the divisional manager, Holdia division of the WBACTCL, intimating the petitioner that the erection of the works, pertaining to which the petitioner has a grievance on the ground that a pole is being installed on the petitioner's land, is being done by the National Highway Division number Roman 2, Public Works within bracket roads bracket closed directorate, for which the petitioner was requested to contact the said department. Subsequently, the petitioner has intimated his grievance to the said respondents, being the PWD, Vide communication dated July 5, 2018. Next para, however, till date, no action has been taken by the respondents thereon. Next para, accordingly, it would be premature to adjudicate the merits of the dispute of the petitioner at this juncture. Hence, WPA 21762 of 2018, along with IA number CAN 1 of 2022, are disposed of by directing. Which respondent should be directed?
Your lordship, my lord, it can be, my lord, the
Respondent numbers
2, chief engineer.
2 to 5,
Yes,
2 to 6 actually.
Yes, I'm grateful.
Directing respondent numbers 2 to 6.
Yes.
To decide the representation given by the petitioner annexed at page 48 within bracket annexure P4 bracket closed of the writ petition, upon giving an opportunity of hearing to the petitioner as expeditiously to the petitioner and all other interested parties, as expeditiously as possible, positively within 8 weeks from the date of communication of this order to the said respondents by the petitioner. Full stop. No rest to cause certain certificate.
Deeply obliged.
Once you communicate, 8 weeks
Yes,
from that.
yes, deeply obliged.
Thank you.
Item 2.
Lordship, in item number 2, item number 30, 45, and 46, Mr. Dhod is appearing on behalf of the
Yes.
Regulatory Commission. He has lost his mother today morning. I'm asking for a fortnight's time.
When should I keep it?
15 days after.
After fortnight or?
After fortnight, then should I keep it after the vacation or?
Even for the petitioner I am appearing, then we will require some time because we are already discussing with the regulatory commission.
Yes, Mr. Bose, after vacation I'm keeping it. You are for the Regulatory Commission.
Regulatory Commission.
An adjournment is sought on the personal ground of the learned senior advocate appearing for the West Bengal Regulatory Commission, although the other parties are represented through counsel. Full stop. Accordingly, the matter is adjourned and shall next be listed on. Mr. Bose, give me a convenient date after the vacation.
Well, as per your lordship's convenience.
Well, I'll keep it in the monthly list of June, whenever suits all of you. Yes, Mr. Banerjee, and it.
Lordship,
Hopefully, he will be back.
Yes, by then.
instead of monthly list, lordship, because they have already taken out money from my covered. So
Monthly list does not mean anything different from the daily list.
এটা একটা council
Not too many matters.
মারা গেছে কি
No,
বলছি
There is one CAN application listed along with this.
Give the CAN number.
can is can 1
Yes, it is there already.
We have not been served.
ওখানে
Oh, they will serve.
this
Right now.
can
Acha, shall be listed in the monthly list of June 2023. Please ensure that a copy is served. Mr. Bose, please ask your junior to give a copy to him.
yes
That is not an issue. Very.
Lordship, should I write the other item numbers or I should wait?
Oh. Which are the other item numbers?
Item number 30.
No, the petitioner should have a notice of those matters. When they're called on, please just either
Yes,
you
sir.
remain or keep somebody so that they can, you
Yes,
can
sir.
keep your junior most member of your chamber. I mean, he'll just mention it.
item 3.
if for the petitioner.
Yes, please. What is the grievance? You have served on the CSC limit.
Yes, my
they
lord,
were
on
appearing also.
on the last two occasion, due to my delay or due to transport problem, I could
Oh,
not
achha.
appear on time. It was hard much before.
What is the matter?
My prayer is so that the respondent number one, I am a lawful occupier, and there was a civil dispute regarding which I have obtained injunction. And my prayer is that I may be get electricity connection within my occupied portion and with police help.
You were a co-sharer.
No. I have purchased the property, but there could not be any sale deed because it is a cantonment area.
There is no sale deed. How can there be?
No, I am occupier. I am not an owner.
The proof of your have you served properly on the have you served properly on the private respondent?
Yes, of course, all of them. Occupier means that is I am also getting an injunction order, that is in the page number 53 and 54. The said order is mentioned 54.
That was an expertise order.
That was
expertise order is equally
now it is persisting even after the appearance of the private respondent number 3.
No, where is that? Which page number?
Page number 54, my lord.
54.
54.
(52) is the last page here in my.
My lord, I do not know how it is happening.
I'll give it to you. I'll please check up and just find out the page. কোনো ভুল pattern না তো?
কোনো একটা গন্ডগোল আছে 46, my lord. It was, but there was some mistake in page number 46. Sorry, my lord. Number 46.
46 ওটাই দাও
46. এটা হয়ে গেছে মানে ডবল মার্কিং হয়ে গেছে।
Status quo regarding possession.
Status quo regarding possession. And I am.
We have to show something else regarding possession also.
My lord, I am.
Expertise status quo order is not.
Yes, my lord. That is my document. That I am possessing the property.
Achha, there are two notarized agreements.
Yes, my lord. Notarized agreement. Yes. By which I have paid money. It is conclusively proved. I paid some money, but as it is a cantonment area.
For a developer.
No. In a cantonment area, there cannot be outright sell deeds. In a cantonment area, my client lives in a cantonment area. He paid money to the owner. That is the respondent number 3. After that, there was after such payment, my client is possessing the property, and it is specifically mentioned in the order of the injunction that I have prior case based on different public documents. My lord, kindly have a look onwards from the page number 44. At the time of injunction, I paid. It is mentioned that I paid something, and there was a 144 proceeding. That is mentioned in page number 45, and in the
page 45 says this is a suit for declaration. Read the last paragraph of page 45. That is the only thing regarding here.
Yes, my lord. This is a suit for declaration and permanent injunction. It is well settled principle that for consideration of grant of injunction, and the plaintiff has to establish a prior case on his behalf. The plaintiff have filed certified copy of 2 number of notarized agreement, which was drawn up between himself and the defendant, one for the purpose of construction by the plaintiff over additional property, and the other for purpose of sale. Now prima facie contemplate that there must be bona fide dispute requiring determination.
The
without-
very well. That is
Yes,
the only
yes,
thing.
yes.
The two agreements have been mentioned.
The
Nothing.
agreements have been
It has
mentioned.
not been stated that you are in possession.
No, my lord, I have received.
Show me from the agreement that
Yes,
there was any clause handing over possession to you.
yes, I have.
Show me from the agreement. You have annexed the agreements. Show me from that. Either of the agreement, please show me that possession was also handed over to you. Something prima facie. Code below says you have an
On perusing the affidavit, last line.
court's perusal won't do. Please give show me from the agreement. There are two agreements. One, you
Yes,
are
yes.
entitled to construct on that property.
Ah.
Two, plaintiff defendant will sell it to you.
Yes, yes.
They will sell to you and you will construct. That does not give a possessory right.
No, my lord, I after payment, my lord, kindly.
Obviously, after payment,
Yes, I have.
you
paid.
have a right to construct and you have a right to purchase. Those are actionable claims. You
have
can file
paid-
suits
I
on
have
that.
paid some money, my lord. It is in page number 44.
Money won't do. Show me that possession was also handed over. Otherwise, you don't have any prima facie case for possession.
My lord, in page number 44, issued property as per contractual obligation under oral contract.
You understand what I'm saying, Mr. Bhattacharya?
Yes.
What are you understanding? Tell me.
After,
I'm not wanting to look into the order at all. Show me from the agreement there is something regarding possession being handed over. From your agreement.
Let me show.
You are placing your case,
Yes,
your contention before the court below. How is it material even?
Yes, my lord. I am.
পেজ 18, 19, 20, 21 দেখুন ওখানে
You have capacity and experience to raise the construction.
And afterwards, I paid rupees.
Therefore, you are not a
6 lakh.
developer.
Rupees 6 lakh.
Saying.
That is in page number 20.
Page number 20.
Page number 20 of the running page. Yes, my lord. The vendor agrees to sell and agreed to purchase one flat being flat number 1 on the ground floor from site.
probably page number 21 from point, clause
20
number
at the
7,
21.
I think.
Ah.
Some possession.
Some position was given.
No.
Clause number 7, I think.
7. Read it out.
Yes, my lord.
Read out.
After possession of the unit is taken over by the purchaser.
Is taken over.
Yeah, the purchaser shall not be entitled to raise any dispute or claim against any amount.
This is not a proof that possession was handed over. Rather the contrary. It says when possession is handed over, this will happen.
My lord, I have let me file and supplement affidavit showing that that the Aadhaar card and except electricity, everything is in my name.
Electricity is in your favor.
Electricity, other than electricity, every proof of documents is with me.
Aadhaar card and
it is mentioned in the plaint in the lower court. Let me show you, my lord. I have
Aadhaar card and what other document I'm asking you. You read out from the plaint, tell me what other document you have.
yes, my lord.
You are given a right to develop, it will be sold to you. That does not confer possession on you to take electricity connection.
My lord, I have mentioned in that depend. My lord, the plaint is not there. I am going to
Plaint may not be there. So I'm not castigating you on that. Even if it is written in the plaint, tell me what document.
The plaint is
If you can't tell me what document, Mr. Bhattacharya, I reject it right now.
Plaint
You will have to tell me what documents you will produce, and I'll record that in my order. You will have to produce those documents on the next.
Aadhaar card is with me that I am and some other document I just cannot remember. But the learned code below.
Very good. I'll give you opportunity.
Yes, my lord. Aadhaar card.
How soon can you file that supplementary affidavit? Tomorrow?
Within 2 weeks.
2 weeks. I'll give you
One,
2 days.
one.
2 days.
Let me.
You have the documents
Yes,
annexed.
yes, yes, yes.
They're already there.
Already they are
They'll
with
be
my
prepared now.
plaint. But my plaint is not just with me.
The petitioner has sought to make out a case of settled possession, comma, on the ground of which the petitioner is seeking to get electricity connection at the premises in question. First up, for such purpose, comma, the petitioner places reliance on certain notarized agreements allegedly entered into between the petitioner and the private respondent, as well as an ex parte order of status quo passed by a competent civil court. For sub next para, it is seen from the said order dated August 23, 2022, passed by the civil judge, junior division,
Senior
sorry,
division.
civil judge, senior division, second court at Barashat, that the said court observed that the petitioner has a prima facie case for injunction and directed both parties to maintain status quo as regards the possession of the suit property as on that date. Full stop, next para. In the reasoning of the said status quo order, comma, the court went on to observe that the plaintiffs within bracket present petitioners bracket closed have filed certified copy of 2 notarized agreements which were drawn up between them and the defendant, comma, one for the purpose of construction by the plaintiff over the A schedule property and the other for the purpose of sale of B schedule property to the plaintiff by the defendant. Full stop, next para. Even in the agreements in question, comma, it is indicated that after possession of the said unit is taken over by the purchaser, comma, the purchaser shall not be entitled to raise any dispute against or claim any amount the owner stroke vendor on account of any constructional defect, etc. Full stop, next para. The very clause indicates that when possession was given, the rest of it would come into effect. Full stop, as such, comma, prima facie, I do not find any proof that the petitioner is in settled occupation of the property concerned. Full stop, however, comma, at this juncture, comma, learned counsel appearing for the petitioner seeks to file a supplementary affidavit annexing further documents to indicate prima facie that the petitioner is in occupation of the property in question. Full stop. Hence, such opportunity ought to be given to the petitioner. The matter is adjourned till May 8, 2023, when the petitioner shall file a supplementary affidavit to the above effect upon service of a prior copy on the learned advocate appearing for the CSC Limited.
I'm grateful.
Thank you.
Item 4. Mohim Sajmal, in this matter, he's the petitioner. Last week, his mother was expired, so I'm paying for Mohim Sajmal. His mother was expired last week.
When should I keep it, Mr. Pandit?
My lord?
When should I keep this matter?
2 weeks adjourn, my lord.
Shubhadeep Sahu. Shubhadeep Sahu.
Shubhadeep Sahu.
Shubhadeep Sahu is the petitioner.
Lordship, I am for the respondent.
Should I keep it after vacation or before vacation? Today we are on 1st May. We have till 19th May.
As you lordship, my lord.
Lordship, the only thing is, my lord, the last occasion, my lord was pleased to direct my lord, the WBCTCL to hold my lord second inspection. That is complete. And to
You have got the report?
Yes.
So I'll take on record the report. I'll keep it on 16th November, May, then 16th May.
And
After
I'm handing over one report also to my learned friend so that he can complete you.
Yes.
On the ground of learned, on the personal ground of learned counsel for the petitioner, comma, an adjournment is sought. Full stop. Hence, the matter is adjourned till May 16, 2023, when it will next be listed. Full stop. The report filed today by the WBSCDCL in court be kept on record. Full stop. A copy thereof has been handed over to the learned advocate appearing for the petitioner. Yes, please just give it.
16th May, Lordship.
16th May.
16th May, yes.
Lordship.
Item 5.
Lord, I am for the petitioner, my lord. Yes, sir. What is your matter? Your lordship, give 2 chances to avoid dismissal, my lord. None. Probably I am not eligible for any chances. Why? This is very bad case, my lord.
My lord,
What happened? I don't get you.
Yes, my lord, case of pilferage, first time caught, my lord, FIR lost, thereafter disconnected, thereafter second time inspection made, again found he is running another submersible pump by hooking, another FIR lost.
Ultimately, I have been acquitted from all the cases, my lord. So what is your prayer in the writ petition? Kindly allow me to withdraw the writ petition with liberty to approach before the authority, my lord.
Yes.
No, you want to pay by installments?
What?
That order has already been there, my lord. First.
And my lord, yes.
So what is the scope of challenge in the writ petition? Tell me that at least. No new case after the order passed by my lord Justice Shekhar. No fresh case want to withdraw, I'll not go into the merits. I'll
Yes.
just leave it. On the prayer of learned counsel for the petitioner, liberty is granted to withdraw the writ petition with leave to approach the WB-SCDCL with appropriate prayer. Full stop. Accordingly, WPA 6045 of 2023 is dismissed as withdrawn. Full stop. The petitioner shall be at liberty to approach the WB-SCDCL with appropriate reliefs. Full stop. If so approached, comma, the WB-SCDCL shall consider such representation in accordance with law.
Yes.
Whatever that means.
Yes, yes.
Yes.
Item 6.
Item 6, my lord, I'm for the petitioner, Mr. Maloy Ghosh appearing for the petitioner, my lord. He is, my lord, ill, my lord. He could not come, my lord.
When should I keep it, Mr. De?
Next week, my lord.
Mr. Kaur, should have
Yes, sir.
told Mr. Kaur he would not perform.
But I understand, Lord, they were to serve, Lord, the.
But I have
electricity
sent, I have
regulatory
served, my
commission.
lord, the copy of the petition to the WBERC.
Received?
My lord. Received, my lord, on 25th, my lord.
Very good. Mr. Kaur, when should I keep it? Tell me.
Lord, my learned friend says next week, so.
I'll keep it next week.
11th,
11th,
onwards,
very
Lord, any day.
Very good.
11th.
Affidavit of service filed today be kept on record, which indicates that the West Bengal Electricity Regulatory Commission has been served in the meantime. Full stop. An adjournment, comma, however, comma, is sought on the ground of learned senior counsel appearing for the petitioners. So accordingly, let the matter stand adjourned till May 11, 2023, when it will be next enlisted. Thank you.
Item 7.
Lord, I am for the private respondent.
Only private respondents are there. Only private respondents are there because petitioner is the WBA-CDC.
Yes, I am for the private.
Yes. What is the case?
My lord, this is affidavit of service. But my lord, only respondent number 2, ombudsman, it has been returned but not required because WBSC has been served. Here in short, my lord, the case is for the month of, my lord, April and May 20. My lord, the two bills were raised, my lord, were amounting to rupees 5 lakh something.
It's all the take.
5 lakh something. And my lord, that has been paid by the consumer. Consumer is a bulk, my lord, supply enjoying.
April and May, which year you said, Mr.
20.
Very.
During the COVID period. Now, you know, thereafter they made an application saying that our factory was not making any commercial production. Therefore, there was no consumption at all, make it 0. Though they have paid it. So that is the dispute, lordship. So we
They
said
want a refund of the to adjustment of the term.
either of the two. Either
So what is your ground of challenge, Mr.?
Now, my lord, that
What has been done here? Ombudsman has allowed that.
No, my lord, RGRO said no, it is rightly paid. So that is okay. But the meter was defective. So on the basis of the average, my lord, consumption as per the clause, relevant clause, that has been assessed. And my lord, RGRO has said it is rightly raised. You have paid it. Very good. Then, my lord, being aggrieved, he challenged the, my lord, order before the ombudsman. Ombudsman made some imaginary observation, no specific, my lord, observation, and has said no, that is bad. I said, reset the order of the RGRO, there will be zero consumption. Now, my lord, why it is important for the WBCTCL? Taking this plea, my lord, there will be hundreds of cases like this, then you will either refund all this. Now, my lord, he was enjoying, my lord, 2 bulk supply, this consumer. And in 1 bulk supply, during that period, he has consumed it, admitted, and my lord, he has paid it. But in respect to another supply, he is saying there was no commercial production, there was no consumption at all, you refund it. Now, my lord, the company said very well, you make information, give information on your self-declaration. In his self-declaration paper, he has said there was consumption of 270 unit. So at least, my lord, there was no reason for the ombudsman to say there was zero consumption. I am showing, my lord, lordship, their statements. Lordship, kindly
First, let us start from the ombudsman and we'll go backward.
I see.
The imaginary
Lordship,
observations as per your
lordship. Before that, lordship, only 1 page, I am showing page 32. There is a declaration of the consumer. There he has said what he was using. Lord, point number 1, use 2 tube lights in security room, 24 units. Use 1 fan, security room, 41 units. And 12 LED bulb outside the premises, 144 units. And use water pump, 68 units, 277 units. He utilized, that is his own declaration. I will, my lord, refer it as a relevant point of time. Let me come, my lord, go to the, my lord.
Not actually, although it was a commercial connection, all consumption is commercial, but this is not a commercial connection. This is the just basic maintenance, security and all.
Zero consumption, because all these consumption
Not zero.
Not zero. But ombudsman has said there will be zero consumption. So I say, my lord, this is basically the admission of on the part of the consumer. There was some consumption.
So very low on 554 units you charge it and return the rest.
I leave it to you. But there is no reason. No, now let us, my lord, let you produce, my lord, what ombudsman said. What is the reason for giving all saying that there was zero consumption?
Yes, that has to be said.
Lordship, before that only, my lordship, come to page 66. That is, my lord, that my lord, settlement order was there. Against that, my lord, we filed our objection. This is the objection where we have shown, my lord, two, my lord, we have a comparable chart has been given at page 66. One is, my lord, kindly come to the bottom. Here, my lord, the Post Export Limited, my lord, the consumer ID numbers such and such, meter number such and such, and April 20, 2109, and April 20, 14,514, and bill 1 unit such and such, 11,729, and minus, my lord, this is a calculation. This is in respect to 1 consumption, 1, my lord, connection. It is not, my lord, here disputed. Then, my lord, kindly turn it over. Here also, my lord, he said that this postpay, this is the meter number, and my lord.
No, you are saying, Mr. Naik, your client is saying bill for the month of April 2020 and May 2020 were raised as per actual consumption.
This is
the detailed consumption pattern of the said connection having healthy metering circuit.
Lordship, that was, my lord.
It was not healthy at that point.
No, that was not healthy. That was
in
defective.
this ground goes.
We have admitted, my lord, it's defective, but we say, my lord, there was possibility of consumption. We are not exactly on the figure, lordship. We say there was consumption or not. Now, my lord, what ombudsman has said, lordship, kindly come to that.
An admission has to be taken as it is. Mr. Naik, you cannot embellish that. If they admit that, yes, this was...
No, that is...
So we cannot go on admission more than 554. You say because they have admitted some amount was used.
Therefore, the observation of the ombudsman...
Their admission has to be restricted to those amounts.
Lordship, kindly, even then, my lord, why?
Very well, yes.
Lordship, kindly come to page 69. That's the order of the ombudsman.
Ombudsman, yes.
Now, my lord, I am not placing the first paragraph. The OP licensee has filed a written reply stating that the electricity bill for the month of April and May was generated and served to the petitioner on estimated basis due to defect of the bulk meter. The said bill were being computed on estimated basis based on the consumption pattern of the same month of the previous year, April and May 19, following the relevant...
What do they manufacture? It's a cold storage.
It's a, my lord, not cold storage. My lord.
What is it, Mr. Haldar? What do you manufacture?
Cars. It's similar.
Automobile dealers.
Parts manufacturing unit.
Of which area?
No manufacturing.
What no
In
manufacturing?
Rajarat area.
Showroom.
Rajarat.
No manufacturing. Showroom.
Car showroom.
Showroom, very, yes.
Number that is not relevant what he uses. It's the pattern is there, Lordship. Therefore, for that relevant period, point is COVID, no production, make it zero. We say no, it
Not
is
COVID, Amphan. That's why he asked.
Amphan and COVID also thereafter they have also said. I am coming to that, Lordship. Amphan and
He
COVID.
specifically mentioned Amphan.
Amphan and COVID was running parallel. During COVID, Amphan started also.
They have cited only Amphan.
Lordship.
Due to Amphan, they could not function.
Now, Lordship, they estimate started from the month October 19 and ended in the month of August 20. After generation of the said bills, the petitioner submitted a complaint stating that due to advent and novel coronavirus and imposed lockdowns, as well as due to cyclone, all other operations are closed. In reply to the petitioner's complaint, the regional manager concerned issued one letter asking the petitioner to submit the following documents. Self-certificate should be submitted for the lighting load of any industry to access energy consumption, and later on the lighting load is to be verified by the site office of the WBCT itself. That Milord I have referred to also, that 277. Number 2, the documents regarding the clearance from the government department to restart the industries to assess the number of days the industry was locked down. Submission of supporting documents to confirm that no work was done during lockdown period. The licensee also state that as there is no such amendment of the regulation for the period of such pandemic situation, no such privilege was extended to the petition for rectification of the bill for which they could be benefited. The petition approached to the RGRO and RGRO passed order directing licensee to raise bill as per average consumption of the preceding and succeeding 3 months or during any previous period that may reasonably comparable before the meter was defective. The petitioner's case in substance is that there was no consumption in his meter from 25/3/20 to 17/5/20 due to lockdown for novel coronavirus, but he received a bill for huge amount without any reason. It is undisputed that the period stated in the petitioner was within full lockdown period, and as per notification of the state government, major activities including the activity of the petitioner was closed. On the point of license issued a letter to the petitioner asking him to submit the following documents. Because these are 3 documents I have placed before. I am skipping it over, Lordship. All the documents screened by the licensee are totally irrelevant to the present problem. It is not a prudent demand. There was specific notification for closing the activities, and it is presumed that industry was closed during lockdown period, unless it is reverted by the licensee that the petitioner consumed electricity for running his industry in violation of notification. The licensee has also stated that there is nothing in the regulation WBRC to extend privilege to the petitioner by correcting the bills during lockdown period. On this point, it is admitted fact that the meter of the petitioner was defective from October 19 to August 20. So during the disputed bill period, the meter was defective. So generation of the bill is necessary. Now the question is, in what manner the average consumption can be ascertained? If the meter was not defective, the consumption can be ascertained from the meter. If the dispute runs in the normal period, the bill should have been prepared on the basis of the average consumption of the healthy meter for the preceding and or succeeding 3 months or during any previous and or subsequent period. That may be reasonably comparable. But the present dispute runs through lockdown period when all activities of the industry was closed. The resolution WBRC itself required a period which is reasonably comparable to ascertain the average consumption. There cannot be any period which is reasonably comparable with the lockdown period. So no amendment of the regulation WBRC is necessary to consider the case of the petitioner. Unless the stated circumstances, the only conclusion is that the petitioner did not consume electricity from 25/3/20 to 17/5/20. Accordingly, the bill should have been prepared for the period from 25/3/20 to 17/5/20, showing 0 unit consumption. So, Milord, this is the conclusion of.
But Mr. Naik, this is a very good judgment actually. In the sense, zero consumption, there is some doubt because they have already admitted 544.
Yes.
But reasonably compared, this is one thing we should also consider.
My lord,
this reasonably comparable, this has clicked in my mind in several cases. That reasonably comparable, it should be reasonably comparable. That those words are also there in the regulation.
What are the guiding factor? I'm showing
it's an act of God sort of, I mean, supervening impossibility, act of God, force measure.
During that period, another bulk meter of the consumer. That was running.
Acha.
That was running. I have given in my objection. I've shown it. So during that period, he's the same consumer.
No, regarding the other meter,
meter.
there was a dispute also.
No dispute. They accepted, they paid it. Now they are saying it was defective. That's the defect on the part. That is the
But defect has been admitted by you.
Yes. We have
If
admitted.
defect is admitted during those 2 months,
Not
regarding
2
the
months.
other meter, it's not comparable because the other meter was not defective.
Not defective. I am saying during the period only.
Why should it not pay for 1 month? Because he has made both the payment deposits.
Yes.
On protest, he has deposited this. He said this meter was defective. Please do it
Defective
properly.
and there was no commercial production. I was not
Commercial production.
No, I was not running. Therefore, make it 0. We are against it. We say, during that period,
I'll direct them to direct you to refund apart from these 554 units. This is not a fit case to interfere under 226. This is one of the views possible.
Let me just
Maybe not acceptable to the court also, but this is a plausible view, not a view which is perverse.
But let me just complete few paragraphs are there left for it.
2 paragraphs will complete.
Now, my lord,
yes.
Let me just under the stated circumstances, the only conclusion is that the petitioner did not consume electricity from 25/3/20. But this observation is made by ombudsman. If my lord
Wrong. I'll modify it.
There he cannot say there was because consumer
Cannot
is
set 0.
If consumer is saying I have consumed.
Yes.
But what is the extent of consumption?
You are right.
Maybe dispute.
0 consumption cannot be.
No, when consumer is admitting at the same
He is
time.
admitting certain consumption.
Yes.
And so that admission has to be taken on that.
As your lordship, but I say, obviously he cannot admit which favors him, and he cannot reject who is also disfavor him. But where in the parallelly he is running another meter, same consumer, he had huge consumption during the same period. COVID was running, Amphan was there. Therefore, in my humble submission, this is absolutely imaginary imagination. Had it not be there, my lord's observation is very right. This may happen in some cases, but here did not happen.
So the other connection was regarding the same premises.
Same premises. Same. My instruction is that lordship.
Let me hear them now, Mr. Naik.
They will say, in my objection, at page 66, we have said so. Page 66, we have shown.
You have given the 2 meter numbers.
Two different. It is in respect to another supply, I am saying, not the same supply.
Where do I find that?
Kindly, come to page 66, last paragraph.
Which is adjacent to that Frosties. Yes. Para 2 of your objection. Para 2 of your objection.
Yes. It is also mentioned that there is another connection. I am placing page 66, paragraph 2. Page 66, lordship, where our objection was very specific.
I'm only on page 66. Page 66, para 2. Your paragraph 2.
Yes. It is also to be mentioned that.
Please read that.
It is also to be mentioned that there is another connection existing in the name of the forestry export private limited bearing consumer number such and such, having contractual demand of 100 kVA, address BB and VIP Park, Narayantola, which is adjacent to this connection in the name of the Forest Export Private India Limited.
So those two are adjacent that you are admitting. Adjacent premises.
We are admitting, and
both are for the same business in the same name.
Yes, in the same name, we are saying that there he runs it, and in respect of another adjacent connection, he is saying it was not running 0.
Mr. Naik, where is their complaint? Show me their complaint, initial complaint.
Their complaint, that is at page, lordship. Here is your point that we say that you are admitting in one case adjacent premises, and in your present disputed premises, you are taking advantage that saying that 0. Lordship, kindly come to the complaint that is at page 26. 26. That's the complaint, my lord. May I place it? This is in reference to consumer number, consumer ID number such as meter number such as. We have received the electricity bill for the month of April, May 20 and shocked beyond words to discover that the bill amount for the said period INR 5,49,619. We possibly need not to agitate that the bill amount for the caption period is excessively high. We further understand that due to the advent of the novel coronavirus, COVID-19, and consequential imposition of lockdown in the entire country, whereby all the commercial operations had to be shut down from 25/3/20 to 17/5/20. As a result, operations at our premises was also closed for the said lockdown period. It would be pertinent to mention that here that in the month of April, our entire operation was closed. Consequently, the electricity bill amount to rupees IN number such and such for the said period is erroneous and arbitrary.
Adjacent connection was also commercial connection.
Commercial connection. This is 100 minute, 100 kVA, the bulk connection.
That is
Now, my lord,
education
further in the month of May, we have operated only 14 days, 18/5/20 to 31/5/20, out of which for 25/20 to 21/5/20, again our operation were closed due to the advation caused by super cyclone Amphan. Hence, bill amount to INR 22,92,945 for the month of May is also incorrect. Under the circumstances, require your good self to kindly look into the matter and take necessary steps so that the above mentioned anomaly in the electricity bill for the month of April and May gets rectified.
Very well. Mr. Nagar, get your point.
Well, I say that, my lord, in the same
your
adjustment
point.
you were enjoying.
Let me hear
Therefore-
them. Yes.
My lord,
I'll come back to you in reply, Mr. Naik, if necessary.
my lord, kindly see page 73. What is the order? Accordingly, the licensee is directed to regenerate the bill from 25th March 20 to 17/5 to 20.
Showing 0 unit.
0 unit consumption.
What will be the regeneration? That's meaningless.
The payment made for the period shall be adjusted against the subsequent bill. The bill was paid on protest.
That is there. Mr. Naik is
We
not
are-
arguing
we
it
are-
was not on protest, but on a different footing.
And
What are you running
now-
from the adjacent premises, Mr. Haldar?
That education institute
Which is running online.
that was also closed
No,
down.
no, running online.
Online business was
Online classes were going.
lockdown period. We have some circular on that.
Did you place the circulars before the ombudsman?
We have.
Union Home Ministry guidelines.
This is the Union Home Ministry guideline.
That covered the April and
Yes. Well, kind
what was the 2020 that was in full swing?
it was.
Was on effect from 20th March. First guidelines.
It was the first. Thereafter again.
Point number 4, all commercial establishment.
Very
Regulation.
So ombudsman is correct in this matter, my lord. Maybe some small consumption for the running, but we have already paid the amount we had.
So, Mr. Haldar, if it is a showroom, car showroom,
Yes.
why was the why was the tube light on and the everything? Because this is not a production, it's not a
No.
manufacturing unit. If it was manufacturing unit,
Maybe,
definitely
I
lights could
don't
be on
know, maybe
security.
some worker may stay outside. My lord, that is
Outside
the
of the showroom.
outside of the showroom, maybe Darwan, others, maybe stay security.
What is that page? Yes, page 32 you have stated. At the security room, all in security room, water pump and bulb outside. Very.
That always.
Anything else? Mr.
No.
Yes, Mr. Naik, what in reply?
But I respect submit page 66, my lord, we have given the chart. This is the huge consumption. And but that is at par with your earlier year's consumption. And in the adjacent premises, you were
When
saying
the meter was not defective.
it was not defective. As regards defective, my lord,
Earlier year, the meter was not defective.
not defective.
From that time, you have shown that to be a comparable unit.
No, this is in respect of, my lord, adjacent premises, my lord, meter which was running.
No interference. Mr. Naik.
Running. And my lord, I respectfully submit, my lord, here in case of defective meter, my lord, the law has given my lord, idea how to raise the bill. But the question is, my lord, Ombudsman has said that time it will be 0. He has not taken note of the fact in the parallel. He has no observation has been made.
I'll rectify that.
That should have been clarified by the Ombudsman itself. Factual aspect, factual basis is there, Lordship.
Learned counsel for the petitioner, being the distribution licensee, submits that the ombudsman acted patently dehorsed the law and in a perverse manner in observing that there was 0 consumption for a commercial unit with regard to electricity. Full stop, it is submitted that even as per the self-declaration of the petitioner, comma, self-declaration of the private of the respondents, comma, some amount of electricity was consumed during the relevant period, comma, which is April and May 2020. Full stop. In spite of the same, comma, the ombudsman proceeded on the premise that there was zero consumption and directed regeneration of bills on such premise. Full stop. It is argued by placing reliance on the submission of the licensee dated July 18, 2022, annexed at page 66 of the writ petition, comma, that a comparable comparable commercial unit immediately adjacent to the premises in question, comma, also run by the respondents, comma, consumed huge amount of electricity during the relevant period, comma, which has also been admitted by the respondents. However, comma, insofar as the present premises are concerned, comma, the respondents took the plea of the COVID pandemic and the Amphan cyclone. Full stop. Next para. Learned counsel appearing for the respondents places reliance on copies of orders passed by the Government of India, comma, Ministry of Home Affairs under section 10 within bracket 2 within bracket 1 of the Disaster Management Act during the said relevant period, comma, introducing lockdown for such period. Full stop. It is submitted that since April and May 2020 squarely fell within the purview of such lockdown, comma, there was no operations run by the respondents at the premises in question at the relevant juncture. Full stop. Insofar as the adjacent premises is concerned, comma, it is submitted that the same is an educational institution, comma, which was operating online during the COVID period, comma, leading to the electricity consumption which has been admitted. Full stop. That apart, comma, it is argued that the meter in question was defective during the relevant period, comma, which fact is admitted by the licensee, and, comma, as such, comma, the readings taken by such defective meter cannot be relied on. Full stop. Next para. It is seen that by way of reasonably comparable period, comma, the licensee has taken a period of time of operation of the commercial unit of the petitioner at the relevant premises, comma, which is an automobile showroom, comma, was a period when the business of the petitioner was running in full swing, comma, there being no pandemic and stroke or cyclone. Full stop. Next para. The ombudsman has proceeded on the premise that the period that such period of regular business by the respondents, petitioner bolechi, business run korche respondent, such period, comma, when the business of the respondents was running in its totality, comma, cannot be taken as a reasonably comparable unit, comma, due to prevalence of the pandemic and the Amphan cyclone at the relevant period, comma, that is during April and May 2020. Full stop. That apart, comma, the meter in the premises was admittedly defective during such period, comma, which leads to the calculation as provided for in the regulations framed by the WBERC, full stop, as correctly observed by the ombudsman, comma, such regulations point to 3 preceding or subsequent months, comma, to be taken as a reasonably comparable period. Full stop. In the present case, comma, the period taken for comparison was not reasonably comparable with the period in question. Full stop. As such, comma, the as such, comma, there is no patent perversity or illegality in the exercise of jurisdiction by the ombudsman. Full stop. Next para. However, comma, since the respondents themselves have admitted a minuscule consumption of 554 units during the relevant period, comma, which has been attributed to electrical devices operating in the security room of the premises and outside the premises, as well as a water pump, comma, which might have been necessary to be maintained for security of the premises even during the pandemic period, comma, the ombudsman ought to have given credit to the licensee for such units. Full stop. Hence, comma, the impugned order of the ombudsman dated
23/8/22.
yes August 23,
Lordship.
August 23, 2022 is modified to the extent that the WBACDCL shall regenerate the bills for the period from April to May 2020, comma, on the basis that the consumption of the respondents was 554 units for the concerned premises during such period. Full stop. Upon regeneration of such bill, comma, the licensee, the respondent license, the petitioner licensee shall refund the balance amount
Refund or adjust?
and or adjust the same with future bills of the respondents, comma, to the extent the same is above the consumption charges for 554 units, comma, which was deposited on protest by the respondents. Full stop. Such regeneration and refund, such regeneration shall be done at the earliest, comma, positively within 3 weeks from date. Full stop. Next para. The refund shall thereafter be adjusted with subsequent 3 billing cycles and or be refunded outright to the petitioner as per the choice of the respondent licensee.
But it cannot be, it can be 3 or 6 lordships.
3.
Petitioner license. Petitioner licensee. This one.
Oh, petitioner license. The petitioner licensee. হ্যাঁ petitioner license সব জায়গায় হবে আর respondent হচ্ছে তার চালাতে
Lordship.
পারে
Adjustment.
because it's the other way around. Generally, Mr. Haldar, I was being confused. Yes, Mr. Naik, not interference under 226. Probably in an appeal could be considered, not in 226.
There is no provision for appeal, lordship.
No question of appeal. That's why these things are not appealable.
Because there is no reason given. But he seems it is not taken care of. There was
The
0, make it
certified
0,
copy, you will
make
find
it 0.
release there.
So
Yes.
there must be check.
Take up the next
That's
matter
how
after
we
10
will
minutes.
Grateful, lordship.
As a WP such and such is accordingly disposed of with the above directions.
Grateful, lordship.
We'll come back in 10 minutes. What is it?
In earlier occasion, my lord,
Take the microphone a bit upwards. Please take the microphone a bit upwards.
in earlier occasion, my lord, the in respect to privatization, the service are not complete.
Now complete.
Yes.
Good service.
Yes.
Due to their obstruction, you are not getting it.
Yes. 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 my lord.
Act order নিয়ে despite good service, none appears for the private respondent at the time of call. The affidavit of service filed today be kept on record. Full stop. It is a submission of both the petitioner and the WBACTCL that due to obstruction created by the private respondent numbers 6 to 8 and their men and agents, the WBACTCL is not being able to give a new electricity connection as per the petitioner's application, at the premises in question. Full stop. Since the petitioner has the right under section 43 of the Electricity Act 2003 to get an electricity connection to the premises where she is in occupation, such right cannot be curtailed by the private respondents. Full stop. Accordingly, WPA 7549 of 2023 is allowed, thereby directing the WBACTCL to give a new electricity connection to the petitioner at the concerned premises, subject to compliance of all due formalities by the
Yes, my lord, all the formalities have been complied.
subject to compliance of all formalities by the petitioner, positively within a fortnight from date. Full stop. In the event any obstruction is created by private respondent numbers 6 to 8 and or their men and agents, in doing so, the WBACTCL will be at liberty to approach respondent number 5, the officer in charge of the Ramnagar police station, for adequate police assistance. Full stop. Such assistance shall, in such case, be provided by the respondent number 5 on the basis of a server copy of this order and at the cost of the petitioner. Full stop. If necessary, it will be open to the police personnel to remove any padlock or other hindrance put up to resist the WBACTCL personnel from having access to the existing meter board position at the premises. Full stop. It is, however, made clear that such electricity connection by itself shall not create any special right or equity in favor of the petitioner, which the petitioner otherwise does not have, and or prejudice the rights and contentions of the petitioner and or the private respondents with regard to their civil disputes, if any. No rest to cause urgency.
Grateful, my lord.
Mr. Diwan. Mr. Diwan.
Yes, my lord. I missed it.
Thank you.
Item 9.
Yes. Yes, Mr. Sen, what is that?
On earlier occasion, your lordship was pleased to pass an order, my lord, to direct, my lord, the CSC to furnish a report, my lord. He has just handed over the report that whether the...
You're for the private respondent?
Yes, ma'am.
Yes, ma'am.
What does the report say, Mr. Mukherjee?
This is an application for shifting, my lord. Pursuant to your lordship direction, we inspect.
Use the microphone, Mr. Mukherjee.
Pursuant to your lordship direction, we inspected.
Both of you have got copies of the report.
My lord.
Pursuant to your lordship direction, we inspected, my lord. It seems that the private respondent and petitioner has no objection in respect of the shifting of the meter, where, my lord, we kindly see the map, sketch map, which we have annexed with this. To shift the meter board there, subject to payment of the charges at which we have stated at paragraph.
Fair enough approach by the private respondent.
Yeah, they are ready, man.
Very
Subject to,
thank
they
you.
have to make an application, man. Everybody has to make an application for shifting and subject.
They also have to make an, their meter is also there.
Yes.
Are you agreeable to make an application? Join.
My lord.
Thank you so much. Yes. The report filed today in court by the CSC Limited be kept on record. Full stop. It is evident from the same that the private respondent also agreed to construction of a meter room, where the existing connections on the premises in question can be shifted. Full stop. Such a space has been marked in a rough sketch map annexed with the report. Full stop. Next para. Upon query of court, learned counsel for the private respondent agrees on instruction to join the petitioner in applying for such shifting of their meters to the proposed alternative position. Full stop. appreciating such fairness of the private respondent, comma, WPA 7640 of 2023 is disposed of by granting liberty to the petitioner and the private respondent to make a proper application in appropriate format for the shifting of the existing electricity meters at the premises. First up, upon such application being made and due formalities being complied with by the applicants, comma, the CAC Limited shall immediately shift such meter to the new meter board position. First up, meter board position, new meter room. First up, it is expected that the CAC Limited shall undertake such work expeditiously, comma, completing the same preferably within what will be a reasonable period, Mr. Mukherjee, for shifting?
2 weeks.
I'll give you 3 weeks for that shifting.
My lord, one more thing, my lord.
Yes.
The charges must be paid.
1 minute. Preferably within 3 weeks from the date of compliance of such formalities by the applicants. Charges will be paid by them.
My lord.
Yes, that I'll specify.
In this matter, my lord, petitioner before lordship is a very poor lady, my lord. Is from the legal aid. I am appearing on behalf of the legal aid, my lord. So, my lord, if it is, my lord, borne by
no, they are agreeing.
My lord, even the private respondent is a senior citizen. He's 67 years.
Yes.
Which I could find. My lord, the court happens to be the petitioner. And my lord, only there is one private respondent, that is Devjyoti Kaur.
Yes,
And my lord, will kindly take my report. My lord, there are around 5 meters are there. My lord, Jamini Kumar Kaur, Prabhavati Kaur, and Tushar Kanti Kaur. My lord, they are not a party to this.
My lord, they have deceased, my lord. They are the father, mother, and the uncle of the petitioner and the respondent.
Push-up arakta line add kore din. The cost of such shifting shall be borne by the petitioner, comma, since it is the petitioner who has paid for such shifting in the present writ petition. First up, it has been submitted on instruction by learned counsel for the private respondent that the remaining names featuring in the list provided in the report of the CAC Limited, comma, of other consumers at the premises are all near relatives of the private respondent who have since expired. First up, hence, comma, there cannot be any further impediment in complying with the order as passed above. First up.
My lord, one more thing, my lord. No right over the
no question of any right. Either both of you will apply. So what is the question of any right?
And my lord, in respect to charges, it will fall under the compliance of all formalities.
Everything compliance of all.
My lord, actually, there is a partition suit pending. So that's why, my lord, if it can be mentioned.
So both of you are applying. So both of you will have a right on that then.
No, I understand, but right in respect of the property
No, you are admitting they are co-owners.
Yeah. No, I'm not admitting the co-owners. No, my lord. No.
As a character line add kore din, very well. The shifting per se shall not create any special right or equity in favor of either of the parties.
My lord, grateful, my lord.
I'm grateful.
মাধব ওটাও অ্যাড হয়ে যাবে কিন্তু হ্যাঁ একটু আগে অ্যাড করে দেবেন নো অর্ডার ইস টু কস্টের আগে
Item 10.
Yes, Mr. Mukherjee.
For that matter, my lord, shifting the meter, my lord, the CSC already submitted report and your lordship's, my lord, directed they private respondent take instruction.
Mr. Mukherjee, yes. What
But,
instruction?
The report, my lord, kindly wants takes up, my lord, the second page of the report.
You are wanting your meter to be shifted?
No.
That
Private
joint
respondent's meter to
partition was there after
yes.
that?
They want, my lord, the after partition, my lord, I have to shift, my lord, my
Your meter to your portion.
yes, my lord, kindly takes up, my lord, the paragraph 3 of the report, my lord, in the next page. My lord, here your lordship will find column number B, E and F is the private respondent. Apart from these 3, my lord, there are other meters, my lord, I am not, my lord.
They are the diet, my lord. This is a father.
I don't know.
That is not his headache.
Yes, that's why I
That
want to
cannot be
clarify.
attributed to him. He
Yes.
cannot agree for them.
Yes, that's why. My lord, this is, my lord, the first thing. Second, my lord, kindly takes up, my lord, the paragraph 5 and 6. What is their observation? However, the inspection particularly revealed that neither of the aforesaid establishment have separate service, but instead they have drive electricity connection from a common service located in the aforesaid common position of the entire premises in question. The common position was identified in the deed of partition as annexed to the instant writ. It is pertinent to mention that in view of the above, there is no requirement of shifting of the above mentioned meter as they are not encroaching on any particular holding number. So it is their observation. But I am not.
No, that
I'm
cannot
not
help
on
you
that.
because
Now,
in the partition deed itself you have
in the
agreed.
partition deed, Milord, what I find, Milord, Milord, being an officer of the court, I must Milord agree
It's a
to that.
registered
Yes,
partition deed.
it's a registered partition deed, and shifting the provision was there at his own cost. It is also Milord written in the.
He will pay the cost.
Yes. Now the problem is Milord, what Milord, in the preceding paragraph, the electricity authority has found that there is no Milord electric connection, separate electric connection in my premises. So what I will have to do, first I will have to apply for a new electric connection so that the connection can come to my premises first. Thereafter, the question of shifting of meter can be arise, because since there is no service connection at all at my premises, so I will have to apply for that first. Let me apply for that. Thereafter, the feasibility, whatever the position that they will inspect and report before your lordship, and thereafter the whatever cost, my learned friend has to bear for that. That is also the clause of the partition deed.
We have already.
No, they have already identified.
Yes, let them.
So
I will have to apply.
I'll give you 1 week to apply.
Yes. I will do that. I will do that. Kindly specify that at the cost of the petitioner.
The application for service connection also.
The application, I will have to deposit the cost.
You will enjoy the electricity connection. You
kindly take
shifting will be at their cost. That was what was agreed.
But the shifting cannot be done without the electricity connection being applied for.
So what? You will continue enjoying your electricity. Shifting application for service connection, why should they pay?
Very well, Milord. That I will do, Milord, at my own cost. But regarding the shifting
entirely their cost.
Yes.
Shifting in order to already be.
Yes. Actually, service connection, if they apply for a service connection, there will be no question of shifting. So you'll have to pay for the service connection also. If they apply for a service connection, where is the question of shifting? Their meter will be disconnected at these premises. Then his meter will be disconnected at this premises and given at that premises.
My lord.
But I will apply whatever.
No, your application. Yes, Mr. Mukherjee, what is the technique?
Since there is no service connection, why not?
There will be a service connection after they apply.
Yes, they have to apply online, while making
whatever. They apply, they get that service connection. If that service connection is obtained by them, then where is the question of shifting of that meter? You will shift that meter in any event because that's an existing meter. You will shift that to the new connection.
That they have.
Give me a second.
It will be a new connection, new service connection. Mr. Mukherjee is probably right on that. The other Mr. Mukherjee.
চার্জেসটা কি করে দেবে না কিন্তু এখানে যেটা অফার লেটারটা দেবে ইন রেসপেক্ট টু সার্ভিসেস সেটা ও বলছে ওপেন করে দেবে
identify the particular place, right?
But I understand that I will have to apply. Thereafter, they will issue the quotation. As per the quotation, they will pay and the entire thing can be done.
Not so easy.
Whether
they will pay. Yes, shifting is still required if they apply for a new
service. We will put in a new meter.
So this meter will have to be disconnected at their premises.
ওখানে তো অলরেডি 5টা মিটার আছে from the petitioner's meter তো প্রথম সার্ভিস একটা নতুন মিটার ওখানে বসিয়ে দেবো তো যেই মিটারটা থেকে অলরেডি একটা এক্সিস্টিং সার্ভিস থেকে ড্র করছে সেই মিটারটাকে আমরা রিমুভ করে দেবো প্লাস বাকি যে 4টা মিটার আছে সেই মিটারগুলোকে শিফট করে এই সার্ভিস পজিশনে দিয়ে দেবো
there are 5 or 6 meters are there, 5 meters are there,
Their meter will be disconnected at the existing premises, and he will apply for a new service connection. He will get it, give it in his premises.
But we have to remove those meters also from.
Why? Why remove?
Other 4 meters are also have to be shifted,
You are not shifting anything. You are giving a new service connection to him.
I am for
and a new meter.
Other
at his premises.
Other 4 meter
partition premises. No question of shifting the others. Why should you shift then? Let them be there. Whatever is there will be there. You will just disconnect their meter won't be live there, and you will give the connection here. Ashun.
My lord, may I submit one thing?
Yes.
My lord, will you kindly take it up tomorrow? Just give me some time. Let me clarify the facts and then.
Very well. Learned counsel for the petitioner submits that in terms of the registered partition deed between the petitioner and the private respondents, it was the petitioner's duty It was the private respondent's duty to shift their electricity meter to the newly allocated portion of the private respondents. First up, next para, although admitting such clause in the partition deed, comma, it is submitted by the private respondents that the petitioner had agreed to pay for such shifting. First up, it transpires from the report filed by the CSC Limited that the shifting, comma, as such, comma, will require a new service connection to be given at the allocated portion of the private respondent, comma, for which the private respondents have to apply for a new service connection. First up, since apparently the within double inverted shifting, double inverted clause involves giving a new service connection to the private respondents at their premises and disconnecting the supply of the existing meter of the private respondents at the existing meter board position, comma, the application for service connection and consequential payment takes the color of the shifting charges. First up, as such, comma, prima facie, the petitioner is required to bear such expenses. First up, however, comma, to ascertain the further technical feasibility of disconnecting the private respondent's meter at the existing meter board position and giving a new service connection to the private respondents at their own portion, comma, a day's adjournment is sought by Learned Counsel for the CSC Limited. Full accordingly, the matter is adjourned for the day and shall be taken up tomorrow under the same heading.
I'm grateful.
I have recorded in my order so that it helps you. Thank you. Mr. Mukherjee. But you have to pay. Don't make that face tomorrow.
I will pay, but that will be adjusted. If the existing meter, there is a security money. Then if new application will file.
Very well, very well.
That will be adjusted.
Fair enough. Fair enough. Just remind me tomorrow when I pass the order that the existing, those things will be adjusted.
Item 11.
Item 11,
I am
petitioner.
taking a preliminary point regarding maintainability.
Why?
I'm paying for not today.
Why I'm telling you last day.
Are you paying for?
Not today.
Why?
Last
Move the
time-
matter.
Last time was the same.
You are well, you move the matter. What is your name?
Zishan.
Use the microphone.
পুরো নামটা বলবো।
Zishan Mehman.
Mr. Rahman, move the matter. Why not?
I know nothing of this one.
Why not maintainable, Mr. Mukherjee?
Earlier occasion, the private respondent filed a writ application before the Lordship's court for getting new connection. Your Lordship passed the order, and if there is a register with the police.
Who is your senior?
Shondiban Maiti.
He will come tomorrow.
No, madam.
Then you have to move the matter tomorrow if he does not come. Why you? On what ground you are praying for time?
He is not well.
What happened to him?
I don't know.
But I am
Let him take the instruction on this point also, because
Report it.
no,
So when should I keep it?
Next week, my lord.
On the prayer of the petitioner, the matter is adjourned for the week and shall next be listed on May 8, 2023. Mr. Mukherjee, renew your point on the next. Let it senior.
মাধবদা, আমার নাম লিখো। Item 12.
Yes, Mr. Haldar.
I am for the petitioner, Lordship. Lordship, in this matter, Lordship directed to serve the private respondents. Again, Lordship, I have served. Although the affidavit of service is not affirmed, but both the
Refuse.
not refused. It has been returned no such person in the address.
Then you have to serve.
Lordship, may I request the CSC authority to give the details of the private response. They have received the letter of objection.
You will get money if you give a new connection to them.
Lordship,
Not for that.
Lordship, kindly see the annexure, Lordship. Page annexure P3, page 11, Lordship, of the writ petition.
No, letter of objection is there.
No, I have not received the letter of objection. If they have
So
received,
letter of objection must carry that, their address.
But my lord, it is the which kindly, my lord.
Bring that letter of objection.
That we will bring. That will bring.
if
bring
that
it tomorrow,
if that
let us
can
see.
be handed over, Lordship, we will serve again on the.
They'll have to take instruction on that. So affidavit service will file during the course of the day.
Lordship.
Leave is granted to the petitioner to file the affidavit of service during the course of the day, full stop. It is submitted by learned counsel for the petitioner that the envelopes sent to the private respondents have returned with the endorsement. What is the endorsement?
No such person in this address.
Within double inverted, no such person at the address. Double inverted close, full stop. However, it is further submitted by the petitioner that it is the CSC Limited which pointed out that due to objection given by the private respondents, the electricity connection could not be given to the petitioner, full stop. As such, the CSC Limited shall produce a copy of the objection letter given by the private respondents when the matter is next called on for hearing. When should I give it, tomorrow?
Only one thing before my lord, my lord, we have only given this letter. We have not given the objection letter. My lord, kindly come to paragraph 9 at page 3. The names of the private respondent has been implemented by the petitioner itself. According to him, my lord, he has not received any objection from us. And we have not been able to inspect also. We have been.
No, you bring that objection later.
Man, I will certainly.
I'll keep that on record. Bring a copy of that. We'll keep that on record. Bring an extra copy for him.
But my lord, we could not inspect, my lord. My lord, we were
very well, very well. Full stop. Let the matter stand adjourned till tomorrow for such purpose. Bring a copy of the objection letter, Mr. Mukherjee. I'll keep that on record and we'll consider that.
That will bring.
Yes, you have given the address. You have taken no objection.
I have instructions that lordship,
So that address was then that was a false declaration.
May I submit?
And he is stating that the objection made by the.
Mr. Haldar, you say
the tenants of
these two people have given me no objection. You give
No, they have not given no objection. They have given the objection, lordship.
You also said that.
Yes.
So you have given the address there.
Yes, I have instruction that both the private respondents are the tenants of the said premises and the existing service position.
You are the landlord.
No, I am also another tenant. And the existing service position of the CSC Limited is
We will consider, please bring the letter of objection tomorrow. We'll consider. Call on the next one.
Item 13.
13, yes, Mr. You're for the response.
Earlier occasion, your lordship has been
I am for
pleased
the
to
petitioner.
direct the petitioner to take instruction whether his client is agreeable to go for a block meter or not. And this is the letter, incidentally, we have handed over to the petitioner upon their application for a new connection. There are already 75 meters in the
lordship.
And he is already enjoying electricity from one of those 75 meters. Now, supplying him with an individual meter, might cause fire hazard or other dangers.
Lordship, may I submit, lordship, after the on the last occasion I took adjournment, lordship. The petitioner is the owner of a shop room, applied for connection, and the CSC authority on the last occasion submitted that they are willing to give connection to the petitioner, and they submitted that
a block meter.
Excellent. They submitted that there are 75 meters in the said premises. Lordship, I have instruction that there is, lordship, 3 service connections existing in the premises, lordship. 1 minute, lordship. Lordship, in one service connection, there is 33 number of meters and another 27 number of meters, and in another service connection, there are 14 meters. And lordship, the petitioner is the only remaining shop owner who has not got a meter. I'm submitting, lordship, if a block meter can be given, and can a single loop meter can also be given on the service connection.
There has to be a last limit of that.
Only 14 number of meters are.
No, the wiring still in the same, Mr. Haldar.
3 different service connections.
Different service connections. That does not mean that the wirings go to some other premises.
And lordship, I have also
the same
premises. There is no
18
no remaining
yes.
applicant for the said block meter.
No, I'll give you liberty to file an application, joint application for block.
There is no remaining applicant, lordship. Petitioner is the only remaining applicant.
There is a union or a sort of cooperative.
You purchase it subsequently. Why don't you have an electricity connection while all the others have? There must be some reason for that.
Lordship, there might be he was deriving supply from another supply. Now it has not been.
It is not possible, they say.
It has
Technically, it's not
given.
possible. I'll record that, and clause 18 is what they rely on. Rightly so.
Lordship, we will apply for block meter, but it has to be in the name of the petitioner. Lordship.
Then you have to apply for a minimum load of that. 6 kV or something.
That
If it is we, at least my lord, 5 to 10 people or 15 people or something like that. Then we can cause an inspection and we can come to a conclusion. But individual supplying an individual meter in that particular area will be very risky, my lord, according to my instructions, because we have caused inspections twice.
Then I'll refer the matter to the grievance redressal officer.
Lordship.
My lord.
I'll do that.
My
Lordship.
It transpires from the report filed by the CSC Limited, a copy of report filed. It transpires from the communication made by the CSC Limited to the petitioner, a copy of which is handed over in court today by learned counsel for the CSC Limited, that the licensee has placed reliance on clause 18 of regulation number 53 of the West Bengal Electricity Regulatory Commission, which contemplates installation of block meters in extremely congested places. Full stop, next para. It has been submitted by the CSC Limited that the location at which the petitioner's shop room, for which electricity connection is sought, is situated is a market area, having large number of consumers, about 75 in number. Full stop, hence, not a single further individual meter can be given at the premises without raising considerable risk of fire and electricity hazard. Full stop, next para. Learned counsel appearing for the petitioner submits that the petitioner is the only shop owner in the said market who is deprived of electricity, for which it will be difficult for the petitioner to gather other applicants to obtain a block meter. Full stop, next para. However, it is seen from clause 18 of the relevant regulation, being regulation 53, that in bastis, markets, etc., where it may not be possible to segregate one consumer from an adjacent consumer because of existence of a very large number of consumers in a relatively small premises, and where because of multiplicity of wirings of such a large number of consumers, there may arise fire and safety hazards, the licensee may effect supply of electricity to all the consumers intending consumers through a suitably located common meter of adequate capacity to be known as a block meter, BRM capital. Full stop, next para. It is obviously the technical expertise of the licensee which has to be called into account on such score, to ascertain whether a block meter is necessary. Full stop. Admittedly, the area in question is a market area, having several other electricity connections. Full stop. Although the petitioner has claimed that there are 3 service connections from which multiple individual connections have been given, irrespective of the number of service connections, the complexity of wiring at a marketplace remains the same. Full stop. Hence, the objection taken by the CSC Limited cannot be brushed aside altogether. Full stop. However, since the issue has a technical element and is required to be adjudicated by the appropriate competent authority, WP 9658 of 2023 is disposed of by granting liberty to the petitioner to approach the concerned grievance redressal officer with the dispute, where the CSC Limited will be at liberty to raise the objection as taken in the present writ petition. Full stop. If such an approach is made, the grievance redressal officer shall give opportunity of hearing to the petitioner as well as the distribution licensee and all others concerned, and decide the issue in accordance with law expeditiously, preferably within 8 weeks from the date of such reference being made. No address to cause urgency.
Great.
Sir, Ghosh, please take back the regulation. I have got copies of this.
Grateful, madam.
Thank you.
Item 14,
I am for the petition.
And I appear on behalf of the CAC, my lord. This is a matter, my lord, where they have applied for a service connection in respect of 100 square feet shop. My lord, we could not inspect, my lord, we'll seek for direction, my lord, to inspect and my lord, to file a report, my lord, we along with police help.
Yes, what do you say?
Lordship, petitioner is the owner and mutated his name in the records of Boj municipality, and it is a structurally separate shop room, Lordship.
Police help for protection from him.
My lord, we have tried, my lord. My lord, we have tried and deputed our men on 10th of October 2022 and 15th of October 2022.
Who objected?
We were objected.
Who?
My lord, this is a physical objection, my lord. We have.
Why objections?
Lordship, I have no instruction regarding objection, Lordship, then I have to take instruction. And who objected, Lordship?
And
have you pointed that out, Mr. Mukherjee?
Well, that is my instruction, my lord.
No, page 12, what is this? No, nothing raised.
This is in respect of the
this is only
convenience to the
Well,
present
not
person for
direct
you.
police help to be given. I'll give you liberty to approach. That liberty you always have, but I'll spell it out in my order. No, you have not given that objection.
But this is the annexure which they have given is in respect of the preliminary stage. My specific instruction, my lord, we have attempted twice for inspection, we could not, my lord. My lord, kindly give us some
I'll
protection.
give that. The petitioner's grievance is that despite having applied for a new electricity connection, no such connection has yet been given by the CSC Limited, for which the present writ petition has been filed. Push up, learned counsel for the CSC Limited submits on instruction that when the CSC personnel went to have an inspection for the purpose of giving electricity connection to the petitioner's premises, a severe objection was taken by people in the locality for which the inspection could not be held. As such, learned counsel seeks police help to hold such inspection. Since no specific objector has been named, the petitioner cannot be directed to implead such objectors as parties. However, the electricity connection, in any event, will be given by the CSC Limited only upon being satisfied of the feasibility and upon satisfaction of all due formalities by the petitioner. For such purpose, the CSC Limited shall hold an inspection within a week from date upon prior notice to the petitioner for the purpose of ascertaining the feasibility of installing a new electricity, for giving a new electricity connection to the petitioner at the premises in question. In the event the CSC personnel are obstructed obstructed from any quarter, in doing so, it will be open to the CSC personnel to approach the nearest the local police station for
Lordship, Boj police station.
Local police station for appropriate for adequate police assistance, which will be given by the officer in charge / inspector in charge within bracket as applicable bracket closed of the local police station at the cost of the petitioner, by acting on a server copy of this order. A report with regard to such inspection shall be filed by the CSC Limited on the next returnable date upon service of advance copy of the same on the learned advocate for the petitioner. The matter shall next be listed on May 10, 2023 for passing further orders.
Good.
Thank you. Thank you.
Specially fixed matter, item 15 to 17.
My lord, item number 15, my lord, I am appearing on behalf of the petitioner.
Yes.
My lord, if your lordship recollects, my lord, I had made my submission that this was a matter where, my lord, subsequent to my payment, my lord, there was initially a disconnection. My lord, subsequent to that, my lord, I paid off whatever was due. And they also asked for certain compliance, which we had done. And after that, my lord, all on a sudden, they came up with this, because in the meantime, my lord, your lordships, the other judgment was passed. So, my lord, they came up with a notice that until and unless you pay back this, the question of restoration doesn't arise. So I had made my submission at length before your lordship, my lord, but since this appeal was pending by the DVC, my lord, before the Honorable Chief Justice Court, my lord, so that was the reason, my lord, that matter was not decided. In the meantime, my lord, there was around 1,700 workers who were working. Now, based on that, my lord, we had no option, but we had to reduce the bank guarantee which we had furnished. 6 MB, my lord, we reduced the strength. Based on that, we made the payment. And my lord, that is 56.3 crores.
3.36 crores.
3.36 crores. My lord, we made it. And my lord, thereafter, my lord, that is how, my lord, the restoration has been given. But my lord, the difficulty is, my lord, what I am wanting, because there is an anticipation that they will further come up with certain other areas, my lord. So what I was beseeching, my lord, no further coercive steps with respect to areas may be directed as per prayer B, and with respect to the regular, my lord, we will be paying.
That is
So
already
we
there
will
in
not
terms of the Honorable Appeal Court.
because we cannot actually take their words, because
But
if
that
they
is
come
already.
up, they will
Can
be
hand over the order. Copy of the order passed by the Honorable Appeal Court.
slicing off one by one, my
They-
lord,
what they
for
are-
some reason.
And this is the order passed by the Honorable Appeal Court, madam.
I have some submissions to make of similar nature. I will make my case. Perhaps their conduct is not in consonance with the letter and spirit of the orders that are.
Absolutely.
Perhaps.
Perhaps.
I would-
Perhaps that is. So we are getting sliced off, my lord, every day. One part of it is sliced off.
So Banerjee was trying to be very polite and
He is very polite, but my lord,
which one not, which one not.
the reason is, my lord, I have already been sliced off. So
So am I, and there is something to be said about the conduct. I will make my case.
So, my lord, I was beseeching in terms of prayer B, my lord, no further coercive steps may be given. With respect to the regular, my lord, we are ready and paying.
You also have your connection restored.
No, it hasn't been. What they're doing, your lordship, I'll tell you. Your lordship, on the last occasion, I had indicated 19th of April.
Please
there
take the
was an
microphone,
order.
Mr. Valis.
I'm sorry. On 19th of April, I had mentioned that there was an order by the Honorable Chief Justice for restoration. There were some errors in so far as the MAT numbers
Yes,
were
yes, yes,
concerned.
right.
And we had mentioned that, got it corrected. That order has not yet been uploaded. Now we communicated that that has been done. Now, apropos that, immediately the day after, what they have done is they have raised another demand charge for a period during which the disconnection had already taken place. From 15th of March, ground being under 4.3.6 regulation, demand charge will remain leviable if it is disconnection due to the fault of the applicant. Now
No,
they
you cannot
construe
say
this. It's absurd.
May I submit, my lord? My
I'll
lord,
put it
the
in my
issue
order.
of disconnection, my lord, whether the disconnection is justified or not, but that is pending before the Honorable Appeal Court.
Not at all.
The
It
Honorable
can't be.
Appeal
It can't be.
My-
It is
my lord, the
completely
Honorable Appeal
misconceived.
Court, my lord, had passed the order, my lord, setting aside the disconnection notice. My lord, that issue is now pending before the Appeal Court. My lord, the Appeal Court has said
The
that
appeal court
whatever-
has
my lord, the-
no
my lord,
interim
this-
order.
the
Appeal
claim
court
is
has
against-
directed restoration.
my lord, the
To
appeal
the
is
contrary.
They are justified.
my lord, the appeal is against, my lord, the disconnection notice which
What
have
will be
been
your
sent-
difficulty if the same order is passed again?
my lord, which order, my lord?
No coercive steps.
But that is already there by the Honorable Appeal Court. my
Again,
lord.
it will be there.
My lord,
I'll reiterate that.
my lord, they are being restored as per the order of the Appeal Court. My lord, now they are seeking before my lord the implementation of the order of Honorable
No,
Appeal
no,
Court,
no,
my
no.
lord.
Perhaps that is misconceived.
The restoration has not been granted by my lord's order. My lord, it has been granted by the Honorable Appeal Court, my lord. My lord, what I was humbly submitting, my lord, the issue of disconnection, whether the disconnection is
That
justified.
in the same breath, you cannot say that an appeal is pending and you will go on asking for that period.
That is current monthly bill, my lord. That is the monthly bill for the month of March, my lord. May I hand
Current monthly bill, I'll specify in my order that current monthly bills you have to pay.
Current, nobody
They
is
cannot.
disputing.
I'll put that in my order. Current monthly bills they will be paying, but
May
you
I- may
cannot
I
in the
just-
garb of current bills. You cannot claim the areas for that.
May I clarify? May I clarify? Your lordship gives me 30 seconds. May I clarify? There are two parts. One is a arrear. Apropos 2000, the main tariff order. Now, subsequently, on 15th of March, pursuant to your lordship's dismissal of those bunch of writ petitions, there has been a claim of arrear by 23rd of February notice. Now, pursuant to that, on 15th of March, they had disconnected my connection, insofar as I'm concerned. Right. Now, apropos that, there was a fresh bunch of writ petition challenging the disconnection notice. Now that succeeded before your lordship. Your lordship was pleased to quash and direct that if somebody's connection has been disconnected, that should be restored. They challenged that. whereby your lordship had held that disconnection notice was illegal. That challenge is pending before the Honorable Chief Justice. Now, in that challenge, while the legality of their disconnection is at large insofar as, so the law as it stands today is, it stands quashed. Now, apropos that, pursuant to that, and despite there not being any stay by the Honorable Chief Justice's court, they are construing 15th March onwards, the period subsequent to or part there of the month, the entire period demand surcharge will be levied because disconnection was due to my fault, which perhaps is not correct. Now, as per Chamundi Mopeds, there is an interim order, there is a final order. Nothing has been set aside. How are they arriving at this conclusion that disconnection was due to my fault? And they have imposed demand surcharge. It's not a current bill. Demand surcharge for the period during which, part of the month, when they had disconnected. I have never refused to pay the current bills.
So for you, they're asking for demand surcharge.
Demand charge, only demand charge.
Demand charge.
Demand charge. As per 4.3.6.
Demand charge is on the basis that is not the contract demand.
That is the contract.
That is the contracted demand, fixed
Contract
demand
demand-
charges.
No, contract demand, those are fixed.
No,
How
but
can you deviate
it is
from that?
not payable upon disconnection as per the regulation.
Achha.
Because on 15th of March, they
One
had
minute. Mr.
disconnected.
Banerjee, if the connection is live, you are required to put in that amount?
Absolutely. The connection was not alive. They have claimed it for a period post disconnection.
Then you'll have to
That-
approach the division bench with that. Because the restoration of connection is by virtue of the order of the division bench.
No, I bow down to that. I bow down to that.
Go before the appellate court.
O-
Because
only-
there will be a conflict otherwise.
Correct. Your Lordship
Maybe a conflict, may not be.
may not be, but only one submission. I stand on a slightly different ground insofar as my writ petition is concerned, because I was not part of the first bunch of the writ petition challenging the disconnection notice.
Maybe,
So
maybe.
my writ petition is alive today, challenging the disconnection notice itself, the 23rd February. That is before your Lordship.
Yes.
In that proceeding, now this relates to the disconnection, the legality, illegality of disconnection. In the other proceedings, that
Mr.
lists-
Banerjee, we are only dealing with that period for which period the areas have been challenged.
Correct.
Now that period they cannot claim.
Correct.
Incidentally, whatever comes in, we cannot interpret that in our stay order on an apprehension. No.
No, I'm not suggesting that, your Lordship.
Incidentally, if you are liable to pay contract demand charges, which you are in any event under the contract, so why not pay those amounts?
It's subsequent to that, your Lordship.
Even
Perhaps
the-
I'm not being able to communicate
No,
myself.
you are trying to put the clock back on the disconnection also. That cannot be.
I'm
Since
not.
they had disconnected, at best restoration can be given to you, which has been given by the division bench.
No, they haven't. They haven't.
The-
They have not complied with that.
No, my lord, the disconnect.
Go before the division bench with contempt.
And what they are now
Let them
doing,
take this point there.
Lordship will kindly indulge me for 30 seconds. 30 seconds. What they are doing is 19th of
30
April.
seconds you're taking.
Last 30 seconds. What they have done is 19th of April, the restoration order was passed. Now, after that, they're procuring a new cause of action, alleging that disconnection was due to my fault, whereas your Lordship has already held that the disconnection.
What is the
notice-
fallout of that? That
Fallout of
allegation.
that is they're refusing to now connect the power on a separate ground again, which they have now procured post the order of restoration. And in the face of your Lordship's finding that this notices of disconnection were bad.
Then why didn't you file a contempt application outright? That will be a contempt. Because the appeal is pending, although the contempt will also be relegated till the hearing of the appeal.
Absolutely, your
But they
Lordship.
can at least answer your query. The basis of their charging
One
cannot just be in the
one
air.
formality perhaps I would also need to comply with before your Lordship passes any teething order is that I would have to bring on record this demand surcharge notice and their,
So that cannot come unless you file a contempt application or something specific.
some application here.
Some
before your
application has
Lordship.
to be.
I'll do so. I'll do so. I'll supplementary affidavit. I'll file.
Lordship, in item number 17, we have already filed the contempt application on similar issues. We have already passed and given an undertaking that we undertake to pay the arrears in case they succeed in the appeal. Now that is wastage of useful labor force. We have been sitting idle. We have already undertook that in case they succeed in the appeal, we shall.
What is their response to that?
The contempt application is pending. Now, they have agitated a new cause, as my learned friend has said, which they have not taken up in the appeal.
My lord, the security deposit amount, my lord, subsequently, my lord, there is a security deposit amount pursuant to the tariff order, my lord. They are not paying the security deposit amount, my lord. Every year, my lord, at the end.
The basis of your charging this amount?
My lord, as per the tariff order, my lord, as per every financial, my lord, kindly appreciate, my lord, the tariff order has been passed. Now, the tariff has been enhanced. They are saying that we will not pay the enhanced.
Only the arrears have been stayed.
Only the arrears have been stayed, my lord.
So that you cannot, that you are not claiming.
Claiming, my lord. I am only
They
claiming.
are alleging that on the basis of the disconnection, you are charging further.
No, my lord, my lord, this is the contract demand charge for per month, which my lord will kindly appreciate, my lord, the issue of disconnection.
I'll just clarify that only on the arrears for that period, the challenged period, you cannot charge any amount.
No, I am not
Or take any coercive action on that.
My lord, that is already there by my lord, by the appeal court, my lord. I am not charging, my lord. What they are saying is that, my lord, that the amount which they are liable to pay towards contract demand for the month.
What is the order date, the division bench?
My lord, 19th April, my lord. I just handed over a copy of the order, my lord.
And there has
my
been
lord,
a
can you see the
corrected-
my lord's last order also, my lord?
And there is I'm told that there is a corrected order where these appeal numbers have been.
Your number has.
That I'm not objecting, my lord. Only issue is, my lord, they are not paying the current bills, and my lord, they are not paying the security deposit.
My only submission was they cannot now raise a fresh claim on the basis of a disconnection which has been set aside by this.
Then you have to clarify this payment of usual charges before the division bench. Because the division bench order clearly says DVC is directed to restore the service connection subject to payment of usual charges. Now, I cannot interpret that.
I bow down.
File a clarification
I
application.
bow-
I'll
I
give
bow-
that
I
to
bow down.
all of you.
In the meantime, insofar as I'm concerned, kindly allow me to file a supplementary bringing on record this, because the writ petition, my writ petition is still alive. I did not have the benefit of the.
You are in which matter?
Item number
WPA?
16.
16.
16, your lordship.
And for you, what is your
My
submission?
lord, we did not make any submission before the appeal court, my lord. So, my lord, whatever was passed by your lordship, and my lord, the direction that in the event you do not bring up any interim.
You are
order
also
of-
covered by this order.
Yes.
In the light of the interim order.
There in appeal before the appellate court in any manner.
You are not a party there.
No, we are not a party there. So, my lord, we would be praying only, my lord, prayer in terms of brief. That is, my lord, item number
You are 15.
15, 1-5.
And your matter?
17, your lord.
17, what is the situation? Scenario is same as Mr. Banerjee. So then you'll have to go before the appellate court for that clarification.
Lordship, we'll do that, but let there be a
Before Mr. Bandyopadhyay comes, I'll pass the order.
restoration of the connection at least. Because the appellate
No.
court had directed that the
No.
connection has to be
Go before
restored.
the appellate court with
And we have already filed the undertaking that in case they succeed in the appeal, we are ready to pay the charges. So
that
that
item number 15 টা heading দিয়ে সবকটা একসঙ্গে হবে কিন্তু
And
item
only one thing I would like to submit, my lord, before my lord dictates the order, my lord. So far as the petitioner now in the first item is concerned, my lord, they had given an undertaking. Now they had not challenged that undertaking. Now the issue of undertaking, my lord, probably has already been taken into consideration by the Honorable Appeal Court, my lord. Kindly see the order, my lord.
item number 15 টা প্রথমে একটা WPA টা আলাদা করে হেডিং দিই learned counsel for the petitioner contends that despite the division bench comma in an appeal arising from a connected issue comma having directed restoration of service connection subject to payment of usual charges comma the petitioner is being deprived of such benefit although the petitioner stands on similar footing as the parties to the said appeals. Full stop. The crux of the dispute.
15 is already restored.
Well, that is the submission of 17 and 16.
But they are claiming further amounts.
They are claiming.
My lord, let them produce anything, my lord. My lord, just
All of
across
you
the
file
board.
supplementary affidavit.
My lord,
Pass, my lord. We are not a party.
তাহলে এটা কেটে দিন সবকটা একসঙ্গে একটা order করুন the common grievance of all the petitioners no Mr. Bandyopadhyay I've heard you already. No.
1 minute, my lord. I'll not take more than 60 seconds. But this petitioner, although situated at par, my lord, he was not protected by any order. So, my lord, there was no appeal, my lord, against your lordship's order so far as this petitioner is concerned. My lord, we asked for the same relief which was granted to the second batch of writ petitions. That necessary, the demand of area demand, my lord, that has to be, my lord, state so far as we are concerned.
File a formal application showing what charges they are claiming from you which are
The
illegal.
area, only area, my lord, that is the case in the petition.
No, you are both of you are in 15.
My lord. He is leading me, my lord.
You are in 15. In 15, what is the scenario? They are charging only the arrears for that period.
Because all dues have been paid.
So this benefit, so I've recorded correctly in 15.
Yeah, but restoration.
Restoration is the. আচ্ছা লাস্টে কি বললাম লাস্ট সেন্টেন্স একটু না 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 তার আগে এটা কাটেন হ্যাঁ
ওকে কানেকশন দিয়ে দিচ্ছে বাকিদের দিতে অসুবিধাটা
এখানটা ফুল স্টপ হবে তার পরের লাইনে লিখুন the petitioner comma whose electricity connection has been restored, it has been restored after disconnect, has been restored after disconnection, comma, contends that since the dispute as to payability of the arrears for the relevant period on the basis of the subsequently assessed tariff order is still subsisting, comma, the arrear charges for such period ought not to be claimed by the TVC for the purpose of sustaining the electricity connection which has been restored to the petitioner. First up, it is further clarified that the petitioner is willing to go on paying the current electricity charges which are payable. First up, next para, since it transpires from the order of the division bench in the several appeals preferred against a connected issue, comma, that the division bench gave the benefit in two separate sets of appeals, comma, in one, comma, the DVC is to retain the payments made by the writ petitioners but you have to file an undertaking then. Subject to filing of an undertaking. I'll permit you to get yourself implemented in the appeal. But unless the appeal is decided, all this is in terms of the appellate court's order. How can I do it?
Your lordship's order was there
So
independent.
that is there independently, but it is sub judice. The same issue is sub judice before the appellate court.
But that has give, my lord, in
Re-
that,
কি
at
বললাম
that
শেষটা?
time, my lord,
Just চেষ্টা বলুন undertaking by the said consumers before DVC that in the event the said appellants are unsuccessful in the pending appeals, they would be liable to pay the demand made by the DVC on account of arrears, and comma in the second comma that the service connection of the petitioners would be restored subject to payment of usual charges. First up, however, comma, since the petitioner in the present writ petition is not a party to the appeal, comma, it is submitted that the petitioner ought to be benefited with the same relief as granted by the appellate court. Full stop, next para, since the rights claimed at present are by virtue of two facets, comma, one, the order of this court, comma, which is under challenge before the appellate courts in connection with the other writ petitions, and secondly, the order of the appellate court itself, comma, neither of which can be directly implemented at the present scenario, comma, since the petitioner is not a party to the said appeals, comma, as well as the order of this court being sub judice before the appellate court, comma, it would only be prudent to give liberty to the present petitioners to renew their prayer for prayer restraining the DVC from claiming further amounts before the appellate court, comma, which is in season of the entire dispute. Full stop. Next para, insofar as the other writ petitioners are concerned, comma, their dispute is that connected charges are being claimed for the DVC on the premise that the disconnection was at the fault of the petitioners, comma, which also cannot be charged by the DVC. Full stop. The question which is to be gone into in those cases is whether the DVC is charging illegally and or dehors the order passed by the division bench, comma, which is in season of the matter. Full stop. Next para, hence, comma, in such cases as well, comma, the petitioners are granted liberty to approach the appellate court for clarification of the order of the appellate court as indicated above. Full stop. Next para, however, comma, liberty is given to the writ petitioners to file supplementary affidavits annexing relevant documents to indicate as to what is the illegality allegedly perpetrated by the DVC in charging different amounts. Full stop. Such supplementary affidavits shall be filed on the next occasion when the matters are taken up for hearing. Full stop. Such leave is without prejudice to the liberty of all the petitioners to approach the appellate court for implement stroke appropriate orders of clarification
And only
with
the-
regard to the existing interim order of the appellate court.
The allegations are denied, my lord. The
One
allegation-
indulgence, your lordship. Could your lordship kindly
No,
add
no,
a
I'll
word?
keep the writ petitions alive.
Yes.
My lord, that is the
Supplementary
What allegations?
which have been that the DVC, and those are not a part.
Very
of the-
well, yes, yes.
Supplementary grounds together with supplementary affidavit, because that might necessitate some
The
supplementary grounds.
documents, if you annex documents,
Very well, very
supplementary.
well.
So আরেকটা লাইন অ্যাড করে নিন। আচ্ছা, সেটা বলে দিচ্ছি। It is since no affidavits, না এটা দেওয়ার দরকার নেই। It will be open to the DVC to challenge the allegations made by learned counsel for the petitioners before this court, comma, as recorded in the above order, comma, at the time of hearing of the writ petitions and before the appellate court. The matter shall next be listed on, when should I keep it? Supplementary affidavit on the
Supplementary, I can file within 7 days. Your lordship.
supplementary you can file, but I'll also have to, I have given you liberty to approach the appellate court also. I'll give you 2 weeks time.
Very well.
2
Very
weeks. The matters shall be listed next on May 15, 2023.
well. Could it be 17th instead of 15th, your lordship?
17th maybe.
I'm deeply obliged. I'm deeply
Much obliged. Much obliged.
to Minister for inclusion.
Mention. Please hand over this.
May I be permitted to
Yes,
mention
all
for
the slips
inclusion?
has. Appellate said all the slips hand over.
I'm grateful.
Contempt application, item 18 and 19.
My pleasure, Your Lordship. Lordship, I am praying for not today. I am being led by Mr. Bajpai. He's gone out of station. If we fix it on
Which matter you have to file affidavits, where is that?
if it already filed, official
Oh, you have already filed.
Replies are already
Here, my lord, the petitioner, my lord, is right now living, my lord, without any salary, in spite of a repeated direction of this honorable court to, my lord, pay the salary, my lord, they did not do, my lord.
You are Mr. Chatterjee.
Lordship.
Yes, you are on record.
At a later stage, railways that appointed Mr. Bajpai as a senior counsel to me.
Even then, have you filed your reply?
Yes, my lord.
What is your ground? What is your ground?
Lordship, right, as per honorable court's order, we have given a letter. You please join. We'll give you a lighter duty. You will get your current month's salary. Still, he has not reported.
Your send is that he's not joining.
On record, it is there. We already sent 2 letters.
Till when do you want the adjournment?
Till Wednesday, Lordship.
Lordship, before my lord, only my lord, Lordship sees my lord's order once. If my lord, because it has been a specific, my lord, direction of this honorable court, that my lord, this matter, my lord, pertains to, my lord, very briefly, my lord, if I can address to your lordship, because I am in real, my lord, need of, my lord, my livelihood. This is why I'm pressing this thing before your lordship. Or I tell your lordship, here what happens, my lord.
No, today you are on Monday. He's asking till Wednesday only.
Wednesday. Oh, I'm sorry. Sorry.
Day after tomorrow. Well, not even a week. But please ensure, Mr. Chatterjee, that you are there. Even if Mr. Bajpai is not there, come prepared in there.
Okay, Lordship.
On the next occasion. An adjournment is sought by the alleged contemners on the ground of absence of learned counsel. Push up. However, learned counsel for the petitioner submits that the petitioner is having to make do. Having to make. You will move the matter.
Yes.
Let us hear the matter.
Yes.
Grateful. Yes.
Well, at the outset, let me say, since I am a condemner.
Mr. Bajpai, can you please use the microphone? Yes.
My lord, the question is, my lord, we are facing some difficulties. Whenever we face difficulties, we come before your lordship. So the question is that the applicant is not attending the office, and your lordship will find from the from our opposition that he has received that we have given him a lighter job. Your lordship's order was to provide him a lighter job. That we have already offered, but since long he is not traceable. And now he is
my case, man.
No, that is true. But now the question is that the area payment. My lord, on that issue, my lordship, I have no hesitation to submit before your
Mr.
lordship.
Bajpai, when can you clear it off?
My lord.
How soon can you clear it off, the areas?
My lord, the question of area payment when he was not serving, that part with the audit, there is some question. So if your lordship gives us 2 months time,
No, Mr.
or I leave it to your lordship only on the question of area payment is there, but whom to pay? Because he is absenting from duty from the date of for last several months.
Give me the joining hour. You will join tomorrow.
My lord, may I place my case, my lord? I tell
No,
you,
don't
lordship,
place
this
your
has been-
case, Mr.
My
What
lord-
is your answer to this first?
My lord, lordship will see because this has been answered by this honorable court's order. My lord, right now, my lord, he is reiterating which has been, my lord, already decided by this honorable court. I tell you, lordship, what happens here. My lord, my lord, lordship will see very briefly, my lord, if I can, my lord, say about this matter, that there has been this particular individual was held to be, my lord, not being able to perform the duty because of his certain kind of illness, for which, my lord, the respondents themselves by their doctors, they placed me under sick list. So, my lord, their law is, if I am, my lord, placed in sick list for more than 6 months, then I will have to be issued with a certificate of decategorization 1 or certificate for change of occupation. They did not. I came before this honorable court. I came before this honorable court. Thereafter, my lord, in spite of this honorable directed, it has to be, my lord, issued this certificate of decategorization or change of occupation. My lord, they did not. Once again, my lord, they said that a different office order that was passed, once again, which led me, my lord, to file another writ petition before this court, when
They, my lord, took the point that during the period of sick list, they directed me to, my lord, attend Shialda division and join over there. So, my lord, I said that I am under the sick list. There has been a direction of this honorable court that there has been a change of occupation or decategorization certificate without compliance. How can you do this? I came before this court. But this honorable court on the earlier occasion set aside, my lord, by the order before your lordship, the sending of myself before the Shialda division. This honorable court was pleased to direct them so that they clear off all my dues because they themselves acted in contrary to their own law.
Let us come to paragraph 31 of that order under contempt.
Yes, my lord.
Page 24 of your contempt application.
Yes, my lord. My lord,
the operative portion.
My lord.
Mr. Bajpayee, please take your seat, both of you. I'll just hear you after him. Yes.
My lord, the operative portion of my lord's order.
Para 31, page 24.
Yes. Hence, in view of the aforesaid finding, WPA number such and such is allowed, thereby setting aside the decision of the respondent authorities to reassign the petitioner to his original post and directing the respondent authorities to immediately issue a decategorization certificate to the petitioner in compliance with the previous order of this court.
So they have not done this.
They have not done this.
In the alternative?
And there, what is being submitted to your lordships by my lord and senior friend is this one, my lord. Setting aside the decision of the respondent authority to reassign the petition to the original post. This is what they are referring
to join in lighter post, they're saying.
My lord, this is what they are right now saying by the order. I tell you, lordship.
They have annexed to the affidavit in opposition also, sir.
Lordship will see what is that. And I have also annexed in my reply itself that it is their case that there is no, my lord, duty of a lighter duty in this particular post. So, my lord, they will have to issue a certificate of, my lord, the change of occupation to somewhere else. So, my lord, during this pendency, they themselves said that you go to Shialda and join over there. I came before this court.
I see their letter from the opposition.
My lord, if I can take your lordship, my lord, to page number 27, my lord, once of the affidavit in opposition in the contempt application.
Page 22. Page 22.
27 years.
My lord, 27, your lordship will see. This is their letter. This is what they're saying. This is their stand. My lord, opposed to the stand taken by my lord and senior friend. In continuation of such and such, my lord's order is recorded. And my lord, I must, my lord, apprise to your lordship, this appeal has been preferred before the honorable division bench, and the honorable division bench has been pleased to, my lord, say that there will be no order of stay in the order of the honorable same bench.
Such observation.
Yes, there has been an observation. I've annexed this. Yes. So, my lord, has been filed before the division bench high court, which is pending such and such. During sick period, lordship will kindly seize this. Second paragraph, have my lord got that? During sick period, your salary was paid up to the month of October 2019 as per due leave in account. But after October 2019, no leave was balanced in your leave account. Accordingly, the salary from the month of November 19 could not be paid. It is, my lord, like talking to the wall. They are once again saying the same thing even after issuance of this honorable court's order. As medical board was declared you fit for duty in present category of railway service as per such and such, video authority number such and such 2021 certificate, and as you were transferred from CLW Shialda to Shialda division 11th of April 2021, you had to report to Shialda division for duty for getting current monthly salary. In absence of any leave in your account and without reporting the duty, salary cannot be credited in your salary account. My lord, this part has been already set aside by this honorable court. The honorable division bench has refrained, my lord, from interfering into this. Thereafter, my lord, once again, they're saying the same thing by saying that since you do not join and all this. And thereafter, my lord,
see the next sentence also.
Yes. In compliance of the honorable court's order dated such and such, regarding current monthly salary, you have been posted at divisional control Shialda. My lord, this is what that has been already interfered with by this honorable court by my lord's order.
Previously were in the same office.
My lord, yes, I tell you, lordship.
They say lighter duty, perform light duty.
My lord, this is what they're saying, but they do not have any lighter duty, which I have the document to show to your lordship. Because they themselves say that in RPF, they do not have any lighter duty. Because, my lord,
so what are you expecting?
My lord,
How should
as
they
per the-
comply then with
as
your?
as per the honorable court's order, my lord, there were two
They
parts
don't
of-
have any lighted duty. They
So
should have
in
put it.
that event, they will have the option for issuance of change of occupation. Like
That was directed also in the order.
yes, this is exactly, my lord, I have been.
They're
filing for
asking
this
you to
honorable
join in the same duty, same
duty,
occupation.
same as a constable, which cannot be done as per themselves. And they themselves say that RPF doesn't have any lighter duty. And on the same thing, my lord, they are right now saying that you're given a lighter duty in the RPF. A self-contradictory, my lord, statement by themselves.
There is no office work or something like that. You are not qualified for that.
My lord, I am. For that reason, they will have to change my occupation. I cannot be a constable.
Is the change of occupation feasible also?
Yes, it does, my lord. It is a railway. They do have a plenty of office work. And if your lordships, because as has already been held by the honorable division bench, that the honorable single bench's order is in perimeteria with the rule. The rule says that it is not that has fallen from my lord only. It is also the rule that they can be accommodated, my lord, by way of issuance of this
And
change
show
of
me what
occupation.
is that at page 22? Their best case.
My lord, this is yes.
Same thing.
Same thing, my lord. They say that go and join Shialda.
Identical letter.
And let us see, my lord, what your
They
lordship has
just
seen
add
about
light
Shialda.
duty. Light duty on
Only
medical.
this is what they are saying. And lordship will kindly see my lord's order, because lordship's order is completely, my lord, with respect to every, has filled, my lord, every corner. There is no doubt in the lordship's order. Lordship will see that. If I can take your lordship, my lord, once. My lord, paragraph number 3, my lord, kindly sees. Page number 2, internal page number 2 of my lord's order. Running page 8 of the affidavit in opposition. Be that as in, my lord.
No, I'm looking into your copy.
Lordship.
Internal page 2.
Yes.
Follow the internal page.
My lord. So, paragraph number 3, my lord, runs as the petitioner was transferred to Shialda division to CLW, force number such and such. Lordship will mark this date, April 2019. This is the date, my lord, which we placed before the honorable court when this matter was being taken up. Then, my lord, kindly sees what has been, my lord, has fallen from my lord. Subsequently, as per allegation of railway, medical board of such and such has been already done. Learned counsel for the petitioner argues such and such, such and such. Despite the direction, the railway authorities constituted a medical board. Subsequently, after about 1.5 years had passed, subsequently the petitioner being put on the sick list, which examined the petition and found out that the petitioner was fit to join his original service, which is, according to the petitioner, contrary to the rule 559 and 561 of IRMM 2000. The respondent authorities, as per petitioner's allegation, would also withhold the subsequent salary and such. 8. Learned counsel appearing for the respondent authorities by placing such as let it be. 9. It is further argued, my lord. 10. After April 1, it is alleged that the petitioner neither reported by the concerned medical officer nor reported as his place of duty. For the entire period, accordingly, the respondent authorities withheld the disbursal of petitioner's salary. Upon hearing learned counsel for the parties, it is seen that the allegation made about the petitioner abstaining from meeting with the medical officer prior 1st of April 2020 are extremely vague. Even after April 1st, 2020, there is nothing on record to show that the petitioner failed to report before the concerned medical officer or at his place of duty. Even if it is assumed, for the sake of argument, that the petitioner has abstained from meeting the medical officer subsequent to April 1, 2020, it is an admitted position that the petitioner was on the sick list with effect from January 29, 2019. As such, the 6 months period of contemplating Rule 561 IRMM 2000 was over on July 28, 2019 itself. After waiting for a long period of about 8 months thereafter, the petitioner was suddenly declared to be unauthorized absent, and medical board was constituted anew, which allegedly examined the petitioner and declared him to be fit to join the original post. It stares at the face that the fresh medical examination of the petitioner and reversion of the petitioner to his original post, to his original duty, was patently dehoused the provision of Rule 559 and 561 of IRMM 2000. As per 561(3), the recommendation for light duty of the employee for serious illness or injury could not exceed a period of 3 months in the first instance, after which the case has to be mandatorily reviewed. Under no circumstances, the period could have exceeded 6 months. In view of no review having been undertaken by the respondent authorities within the said period of 6 months, expiring on such and such, Sub-Rule 4 of 561 is attracted, which clearly provides that if the competent authority indicates its inability to provide light duty or change of occupation, the employee should be kept on sick list he is fit for duty for or decategorized. The period of waiting not exceeding 6 months. In the present case, the constitution of the medical board, much subsequent to the expiry of 1 year after the commencement of the sick listing, was divorced the rule framed by the respondent railway authorities. The alleged absistence of the petitioner for meeting the medical officer post April 1, 2020 is entirely irrelevant to the context in view of more than 1 year having elapsed after the sick listing of the petitioner. The respondent authorities not only failed to issue a certificate of decategorization to the petitioner in terms of such and such of IRMM, in patent violation of the specific direction of the Honorable Court of my lord's earlier order, but also failed to take any step assigning the petitioner to temporary light duty or change of occupation of the petitioner after the expiry of 6 months from the date of commencement of the petitioner's sickness. Rule 559 of IRMM 2000 clearly provides for 3 categories of medical recommendation that are issued to railway employees by railway doctors. The recommendation relevant to the present context is covered by clause 1, which pertains to recommendation for light duty or change of occupation. As per scheme 561 and its subclause, the only option left after expiry of 6 months from the sick listing of the employees either to provide temporary light duty or change of occupation of the employees. None of such recourses were resorted to the respondent authorities. The respondent authorities, in blatant violation of the specific direction of this Honorable Court in such and such petition, refused to issue any certificate of decategorization or change of occupation to the petitioner. On the contrary, the railway respondents, Lordship will see this. On the contrary, the railway authorities were brushed enough to constitute a fresh medical board entirely beyond the purview of the authority conferred under IRMM 2000 and subsequently to declare the petitioner to fit to resume duty in the previous category in the railway service. Hence, the unilateral decision by the railway respondent authorities of the being unauthorized absence or unwarranted and divorced the law. On such erroneous ground, the respondent authorities also withheld the current salary of the petition in unjust manner. The purported transfer order, Lordship will see this. Purported transfer order of the petitioner dated April 12, 2019 was issued during a period when the petitioner was admittedly on the sick list. Hence, it could not have been possible for the petitioner by any stretch of imagination to join service in his transferred post. More so, since the railway authorities have not produced any document to show that such transferee post was lesser in intensity than in the original duty. So this has been, my lord, taken care of. My respectful submission before your lordship. Now, my lord, if I can, my lord, request my lord to once again come back to my lord page number 27. Lordship will see what is their language. Now, during lordship page number 27, the second paragraph which your lordship has already seen. May I, my lord, please? During sick period, your salary was paid up to month of October 2019 as per due leave in account. But after October 2019, no leave was balanced in your leave account. Even after this Honorable Court's order, the Honorable Division Bench's order, they are, my lord, just straight on what they said on the day 1. They just do not understand anything about this. Accordingly, the salary from the month of November 19 could not be paid. As medical board has declared you fit, that same which has been interfered with by this Honorable Court. For duty in present category railway service as per such and such, white duty such and such, 3-21 and fit certificate such and such, 23-21 as you were transferred from Sialda division during April 2021. You had to report the Sialda division for duty for getting current monthly salary. My lord, like a stubborn child, my lord, they are only, my lord, sticking to a particular point that yes, October 2019 you were paid, you cannot be paid after that, and you will have to go and join over there.
Senior Security Commissioner is a party here.
My lord, principal chief personal officer is a party, and my lord, security commissioner, alleged contempt number 4 is, my lord, is a party.
This is Mr. Rathore who wrote this letter.
Yes. My lord,
may not be.
It is the security commissioner.
Whoever was the.
Yes. So, my lord, respondent number 4, alleged contempt number 4, my lord, is the person who has affirmed this affidavit in opposition.
Achha.
My lord, he is the security commissioner, railway protection force. And my lord, in the opposition, my lord, I find that he is himself the senior security commissioner. In the opposition first page, it is written, my lord. So he is the gentleman, my lord, who has been doing this. And even, my lord, in spite of a specific direction by the honorable division, if your lordship kindly sees the honorable division bench's observation once.
Does not find that deserves to be stayed.
Lordship. And also, my lord, sees the reason. Because, my lord, it has been specifically stated, I tell your lordship that particular portion, my lord, if I am permitted, my lord, 30 seconds, my lord. My lord, because we have, my lord, all along, my lord, contended before the honorable division bench that the honorable single bench's order is completely in pursuant to the rule itself. It is the rule only. We said nothing else before the honorable court on the earlier occasion. So, my lord, this has been, my lord, taken care of by this honorable court, the division bench. So this is why, my lord, the honorable division bench was pleased to observe that there was no reason, my lord, to interfere with the order of the honorable.
Not interfere.
My lord, to stay the. Yes, my lord. So that because there has been a specific direction of this honorable court.
Interference will be decided at the final hearing. Maybe
Yes, my
interfered,
lord.
may not be.
Yes, my lord. But at the same time, lord, you will see that the honorable, subject to correction by my lord, that this honorable division bench was my lord, of the observation, though it is not reflected over here, that the interim the protection, my lord, that has been given by this honorable court, but the direction of payment of the salary and everything, my lord, has to be, my lord, complied with. This is why, my lord, the direction of this honorable court was not stayed.
Anyway, so that is not there. Very well. Let us hear them then.
As your lordship.
Yes, Mr. Vajpayee.
My lord, in the division bench, we have made an application for urgent hearing of the stay application. So I am not raising that issue because since we are on the question of lordship's order,
Mr.
compliance
Vajpayee,
of lordship.
Respondent number 4 shall appear in court personally and explain. I'll issue a rule of contempt.
My lord,
In contempt.
my lord,
What is this reiteration of the same proposition again?
yes, yes, my lord.
Same proposition, whatever was set aside, he is reiterating. How dare he?
Yes.
This is palpable contempt, Mr. Vajpayee. Respondent number 4 will be present in court. I'll issue a rule.
My lord.
I'll issue a rule of contempt against 4. 4 for the time being, but regarding the others, what is your stand, Mr. Rai? Regarding the other alleged contemners?
My lord, he is the person.
4 is the person who is the
takes care of this, and he
21.
is standing in the way of compliance of this honorable court order since 2019.
So, my lord, can I take leave for a few minutes?
Oh, yes, Mr. Vajpayee. Heard learned counsel for the parties. First up, it is evident even from the affidavit in opposition of the alleged contemner number
4, my lord.
4 filed on behalf of the other alleged contemners, comma, that by repeated letters, comma, 2 of which have been annexed to the opposition itself, comma, being dated November 19 and December 24 of 2022 respectively, comma, the said contemner has been repeatedly placing reliance on the earlier decision of the contemners to transfer the petitioner to the Shialda division of the concerned railways, comma, in blatant violation of the order of this court. First up, it is clear from the order in contempt passed by the single judge that thereby, comma, the decision to transfer the petitioner to the Shialda division was squarely set aside and direction was given to the respondent authorities to immediately issue a decategorization certificate in compliance with the previous order of the court, comma, in the alternative, to issue a certificate of change of occupation to the petitioner and to assign the petitioner either to a lighter category of service in the railways or with lighter duties in similar category as his original post. Full stop. Such exercise was directed to be completed by the respondent authorities within 3 months from the date of the order, that is from January 25, 2022. Full stop. Next para. Moreover, comma, till the new assignment was given, comma, the respondent authorities were directed to disburse all arrears of current salary to the petitioner. Full stop. Next para. Such disbursal was, comma, latest, comma, to be within 2 months from the date of the order. Full stop. Thereafter, the respondent authorities were directed to go on paying current salary from the month of January 2022 till the petitioner was reassigned to a post as indicated above. Full stop. Next para. It is clear from the tenor of the letters annexed to the affidavit in opposition that, comma, in deliberate and willful disobedience of such order of court, comma, the respondent number 4 reiterated that during sick period, the petitioner's salary was paid up to October 2019, and thereafter no leave was balanced in the leave account of the petitioner, comma, accordingly, comma, the salary from the month of November 2019 could not be paid. Full stop. Apart from such disobedience with regard to payment of the arrears to the petitioner, comma, it was reiterated by the said contemner that the petitioner was to report at the Shialda division, comma, purportedly to perform light duty on medical grounds, comma, till final decision of the division bench in the appellate, in the appeal. Full stop. Next para. It is beyond the contemplation of this court how the recalcitrant respondent number 4 had the audacity to deliberately flout the specific direction of the court to disburse all arrears to the petitioner, as well as to assign a lighter job to the petitioner, comma, in the teeth of the stand of the alleged contemners themselves that there was no lighter offering in the post to which the petitioner was previously transferred. Full stop. In fact, comma, such submission was the premise of setting aside of such transfer order and the specific direction of court to issue a certificate of change of occupation and to assign the petitioner either to a lighter category of service in the railways or with lighter duties in similar category as his original post. Full stop. Next para. The letters written by the alleged contemner clearly indicate that the mere mention of the expression within double inverted light duty, double inverted clause, was used as a ruse, R-U-S-E, ruse, as a ruse to defeat the very purpose of the order of this court. Full stop. Next para. In fact, comma, it is next to impossible to assign light duty to the petitioner or to monitor such assignment, comma, in view of the contemner having repeated its illegal action in transferring the petitioner again to the original post with the eyewash rider within double inverted light duty, double inverted clause. Full stop. It is also seen from the observations of the division bench in the appeal preferred against the order under contempt that the division bench clearly observed that the said court did not find that the judgment and order dated January 25, 2022 deserved to be stayed. Full stop. In view of such deemed refusal of stay, comma, it did not lie in the mouth of the contemners to plead that they would do as per their whims and fancies till final decision was arrived at by the division bench. Full stop. In the teeth of such specific and deliberate contempt of court, comma, a rule be issued on the respondent number 4 for the present, comma, keeping in abeyance the decision on whether rule should be issued on the others subsequently, comma, directing the respondent number 4 to show cause as to why strict action in terms of the prayers in the contempt application should not be taken against the said contemner. First up, such the matter with the cause shown shall be returnable on June 12, 2023, when the matter shall be listed at 2 p.m. for personal appearance of the contemner number 4 and for passing further orders. Full stop. Office shall take steps immediately to ensure that the rule is served expeditiously on the contemner number 4. Full stop.
Grateful, Mali. Grateful, Your Lordship. May I take your Lordship?
Mr. Chatterjee has also left. Arekta line add kore dao to. It may be added here that although leave was granted to the learned senior appearing for the alleged contemners to leave court on the ground of other engagement, comma, during the passing of the order, comma, it is noticed to the chagrin of court, CHAGRIN, of court, that all the counsel appearing for the alleged contemners have left court. Full stop. Such action on the part of the learned advocates appearing for the contemners are themselves is itself bordering on the contumacious, and it is expected that all the learned advocates appearing today initially for the contemners shall also be present in court to represent the contemners on the next date when the matter is called on for hearing.
Sorry, my lord. May I take your Lordship?
Yes.
20 and 21.
Yes. Yes.
My lord, my lord, appeal is pending and appeal is listed for hearing.
Take the microphone.
My lord, appeal is listed for hearing and it will be expected. We have consulted within 11. We pray for next accommodation on 12th, my lord.
Well, I'll give them that time.
Let it be fixed on 12th, my lord.
I will.
So we are suffering, my lord.
I pray for 19. They said that 12.
After the previous order, you are praying for 12. Learned counsel for the alleged contemner submits that since the appeal against the order under contempt has already been fixed for hearing on May 11, 2023,
already listed before the division bench. Listed 11 within 11. We expected it will be disposed of.
Acha, full stop. Has already been fixed on 11th Corona, listed before the division bench taking up such appeal, and the matter is expected to be taken up by May 11, 2023, comma, let the matter stand adjourned till after the said date. Full stop. Learned counsel for the petitioner submits that the petitioner is unnecessarily suffering for the delay made by the alleged contemners in pursuing the appeal. Full stop. Next para, be that as it may, comma, in view of the pendency of the appeal in the list of the concerned division bench, comma, for the sake of judicial propriety, the matter is adjourned till May 15, 2023, when the contempt application will next be listed. Full stop. Learned counsel for the alleged contemners shall apprise the court on the next returnable date as to the outcome of the appeal or whether any interim order has been passed in the appeal in the meantime.
My lord, I beg to submit, my lord. My name is Rammohan Pal. Next, previous order is Rammohan Rai. Surname will be corrected, my lord.
Rammohan Pal ওটা হবে কে নিয়েছিল ওটা তন্ময়
It will be corrected, my lord.
Yes, thank you.
Get,
Write it in your slip this time.
I've handed up a slip today.
Very good.
Yes,
এটা
yes.
দেখে লিখো, রামমোহন রায় করে দিবেন।
My lord, grateful.
Application,
Yes.
item 22, 23.
My lord, I'm praying for not this.
No, not this week. Why?
My lord, I'm led by Mr. Aniruddha Chatterjee, my lord.
So what?
My lord, a client is based in Jalpaiguri, needs some instruction, my lord.
Move the matter, move the matter. What is the application for?
Lord,
My lord, matter is also pending at Jalpaiguri, my lord. Let it be out of list, that is also. Let it be
The
out
review
of
of my own order, it will be out of list, and Mr. Chatterjee is here.
Mr. Chatterjee. So, also.
Yeah, I'm in a little
Yes.
bit of a fix here. Lord,
outside of. So, outside the, application.
review. Lord, in a little bit of a fix. I'm not too sure, my lord, what I should do. Because review of my lord's order, but the point is still, my lord, it's not, one I am arguing, my lord, before Justice Banerjee with respect to Bastu. Whether
Respect to?
Bastu, whether that can be, my lord, preemptible or not.
Bastu.
Then
It is a chance application, Mr. Chatterjee.
Not
So
a-
when will that matter be over?
It'll take a little bit of time. Keeps it just after the vacation.
You are not enjoying any interim
No,
order
no,
in connection
not-
with the review application, obviously. So I'll put it whenever you say.
Just after the vacation.
On the prayer of the petitioner, the matter is adjourned and shall next be listed in the monthly list of June 2023, full stop. However, comma, it is made clear that the pendency of the review application shall not by itself operate as stay of operation of the order under review. Thank you.
Grateful, Judge.
Old matter, item 24.
In this matter, I am appealing for the petition.
Yes, Mr. Mondal, what is the matter?
It's regarding freedom fighters pension matter. my lord.
This is the last chance given to you. You are
Yes.
absent on the last occasion.
Yes,
Who is
yes,
appearing for the other side, Mr. Mondal?
Last occasion I saw, my lord, there is affidavit service is there.
Last occasion means you served the restoration application.
Yes, thereafter I have not.
Those were allowed then.
Those were allowed, not.
Give another notice, Mr. Mondal. I'll keep it day after tomorrow. Give a notice that it will be taken up day after tomorrow. And I'll record that you are present today. They are absent.
If you lordship, so please, I'll serve.
When should I keep it? Day after
Lord-
tomorrow or
Let your lordship kindly keeps it on.
give me a date.
Fourth.
You have to be present on that date.
Yes, 4th. I will be present.
4th, very well.
4th.
None appears for the respondent, although the petitioner is represented through counsel, full stop. The learned advocate on record for the petitioner shall give a notice to the learned advocate for the Union of India, indicating that the matter shall next be listed on May 4, 2023. Full stop. A receipt in that regard shall be filed on the next date of hearing. Full stop. It is made clear that in the event the union chooses to remain unrepresented on the next occasion as well, comma, the matter may be decided ex parte in the absence of the Union of India.
May I hand over the list of dates on today? Or
Over on the next date.
Get full lordship.
Item 25.
Yes, 25.
I am for the petitioner.
What is the matter?
For item number 25, I believe an application is pending for addition of party.
It is not appearing today.
My lord,
এটা অনেকগুলো কেন রয়েছে?
এখন তো সেই থাকবে না নাম্বার, এখন তো নিউ নাম্বার পড়ে।
Addition of party can 2 appear করছি তো লিস্টে। আছেও তো এখানে।
My lord.
Yes, it is there, appearing in the list also.
My lord.
Move there.
My lord, I am the second husband of the petitioner herein. And earlier a marriage was solemnized with regard to challenging that marriage certificate.
the petitioner has preferred this instant writ petition. During the pendency of the writ petition, the petitioner got married to me, and subsequently out of the said marriage, 2 children were born. And now presently several matrimonial disputes are arisen, and due to such several
By
proceedings are
virtue of this,
pending.
what was challenged? Her previous marriage.
Previous marriage certificate.
What is your locus standi to challenge? You're the wife.
I am the second husband.
You are wanting to be added.
Yes, my lord. I don't have anything to say, but the fate of this writ petition will affect my marriage.
Affect you, but your rights are secondary. I mean, secondary, not in your life, but legally speaking, you are incidentally affected. Whatever happens, you are not a necessary party here.
But my marriage
You
becomes-
sponsor your
my-
wife so that she can argue well, appoint good
My
advocates.
matrimonial disputes have cropped up in my marriage also. And several
This
matrimonial
marriage, second marriage.
second marriage, several matrimonial proceedings are pending.
That cannot help you because this is challenged. The lady has challenged the previous marriage certificate.
My lord.
So that will be respective. You married her subsequently.
My lord.
So whatever happened, you are subject to that.
That was totally, I was unaware. I was totally in dark.
That's your separate cause of action for which you must have filed your matrimonial suit or whatever.
My lord.
If that is cancelled, the previous one is cancelled, you will be affected. But you are not a proper or necessary party.
I am not. But the fate of the writ petition will.
You are a collateral damage. If there is damage, otherwise a collateral benefit.
My lord.
No. Addition of party has to be rejected.
Fate will be affected.
You are for the wife, Mr. Hussain?
Yes. I'll be affected by the fate of this writ petition because
You will be.
my
I'll
marriage
record-
my marriage will be void. And that is a ground for my divorce. Because she has kept me totally in dark about her past.
Your marriage will be void if she loses this writ petition.
Yes, yes, yes.
So you cannot ensure that she loses. How can you? I mean, you are a post facto event in her life.
My lord. That is also
No,
that
no.
I was
Subsequent-
totally kept in dark about her
It's
previous.
a very bad analogy. But suppose a suit is filed regarding a registration of a document, regarding a property.
My lord.
Subsequently, another person, purchases that property. I mean, it's a very bad analogy, but don't take it literally.
My lord.
Somebody else has an interest in it. That person cannot be a necessary party in a challenge to the previous registration. This is a challenge to the registration of marriage.
Challenge to the registration. But
No, I'll reject this application.
however, a copy of the writ petition has already been served upon me.
Fairly enough.
And
You know the fate, you know your fate. You can follow the list.
I can, my lord, but
No.
as the lordship pleases.
The present, yes, Mr. You have to add anything?
One thing only in Mumbai International Airport Private Limited case, your lordship knows.
No, I don't know. Forgotten.
Tell me.
What is the ratio there?
The ratio is that a person who is neither a necessary party or a proper party, he cannot intervene. And he has nothing to get out of this.
He has everything to get out
Yeah,
of this,
my
but
entire
as a
life is
collateral.
What we have challenged this marriage certificate with a plea that the incident never took place. And we have challenged the action on the part of the marriage officer.
Mr. If suppose what happens if you lose this matter, then they get a ground in their divorce suit.
Definitely.
Or even, they may say it is voidable.
That they have already filed.
Well,
disputes are
they
going
don't have
on.
a right. Yes. They don't have a right to get added in this. Acha. The scope of the writ petition itself, to which the present applicant seeks to be impleaded, is a challenge by the alleged wife, to a marriage certificate which was issued, primarily on the ground that the incident of such marriage never took place and the marriage registrar acted dehorsed the law and with patent perversity in issuing the said marriage certificate. Full stop, next para. There are several components of the challenge, but the crux is a challenge to the marriage certificate itself between the petitioner and the respondent. No, he's also a respondent, the previous husband.
Yes.
And the private respondent. Full stop. Next para. The present applicant claims to be the second husband of the petitioner and submits that he is vitally interested in the outcome of the present writ petition. Full stop. Matrimonial disputes have cropped up between the present applicant and the writ petitioner subsequently, moreover, in the event the marriage is in the event the marriage certificate of the petitioner obtained previous to the present marriage is cancelled, the implication of that on the present marriage of the applicant and the writ petitioner shall be entirely different from what it will be if the writ petition fails. Next para, heard learned counsel for the parties. Whatever may be the collateral effect of the outcome of the writ petition on the present applicant in the addition of party application, the same per se cannot entitle the applicant to claim to be a necessary or proper party to the writ petition. The writ petition pertains to an alleged incident which took place much prior to the alleged marriage between the present applicant and the writ petitioner. As such, whatever may be the fate of the writ petition, would bind the present applicant, without, however, entitling the petitioner, entitling the applicant to get a relief in the writ petition in any manner. Even if the writ petition is allowed, the same would only affect the present applicant incidentally. The present applicant cannot have any say in the matter of the validity or invalidity of the marriage certificate issued in favor of, in respect of the writ petitioner with regard to a third party, that is the private respondent in the writ petition itself. Hence, there is no scope of addition of the applicant, claiming to be the second husband of the writ petitioner, as a party to the instant writ petition, which would only enlarge the scope of the writ petition unnecessarily. In such view of the matter, Can 2 of 2020 is dismissed on contest without any order as to cost. Who is appearing for the give a notice to the state? I'll take up the main writ petition next week.
Good.
There will be no order as to cost later. Next para. The writ petition along with the connected pending application shall be taken up for hearing on May 8, 2023. The learned advocate on record for the petitioner shall give a notice to the advocate for the state as regards the next returnable date in the meantime and file a receipt on the next date of hearing. Private respondent is appearing?
No.
At no point of time?
At no point of
In spite of service?
In spite of service.
না স্যার পুলিশ ইনভেস্টিগেশন করে বলেছে টোটাল ফলস
আজকে 26
Nurman Bhattacharya was virtually present in the morning, but due to some problem, he has gone to his doctor. So kindly make it not today, my lord. Only not today. His
You
phone.
told me, sir, he would not.
His phone. Last occasion, I have requested
months,
he was operated.
I know he was ill. That's why I not ever opposed.
Only make it not today.
He was appearing online on the last occasion also.
He was appearing on the first half. He was in virtual, but
only not today. Then, but please ensure that you are represented tomorrow. Either
I will
Mr. Bhattacharya or you will have to do the matter.
I will present tomorrow.
Very well. An adjournment is sought on the ground of learned counsel for the petitioners. You are for the petitioner?
No, I'm for the respondent. You
Oh, for the respondents. First up, the learned senior advocate appearing for the petitioners does not oppose such prayer, but it is pointed out that the matter is pending for quite some time. First up, be that as it may, in view of the prayer made by the respondent, the matter is adjourned only for the day and shall be taken up for hearing tomorrow. First up, in difficulty tomorrow?
No. I was searching. What is this?
What is what?
This.
This?
No. Just
The camera.
beside the
Camera.
Camera.
Should be camera. I don't know. I had the impression it is a camera. It may be something else also. Time will say.
What time will say?
Anyway, tomorrow. First up, it is made clear that in the event the respondent is unrepresented tomorrow, the matter may be taken up expert in the absence of the respondent.
এগুলো প্রত্যেক ঘরে ইউটিউবের জন্য।
Next.
27,
The parties are consistently unrepresented when the matter is called on for hearing. Full stop. Accordingly, WPA 363 of 2008 is dismissed for default without any order as to cost.
twenty-eight,
28, my lord, I have got instruction to appear on behalf of the CSC in this matter, my lord. This is an old matter, my lord.
This is a second occasion when none appears for the petitioner. WPA 1786 of 2008 is dismissed for default without any orders to cost.
Grateful.
Probably they are no longer interested. Before 15 years, this was filed. If they're interested, they'll file a restoration application. I'll allow the restoration and take up the main matter.
I'm grateful.
twenty-nine,
Possibly it's infectious.
Same order. Owner নামটা record হবে WBACDCL.
item 30,
Mr. Thor is appearing in
For
this
whom?
matter for WBERC.
None appears for the petitioner, although the WBRC represented through counsel. WPA 7594 of 2008 is dismissed for default without any orders to cost.
Obliged.
thirty-one,
Second occasion, none appears for the parties, dismissed for default without any orders to cost. আচ্ছা এগুলো সব করাতে একটা লাইন অ্যাড করে দিই, interim order if any stands vacated.
thirty-two,
62 পর্যন্ত বোধহয় একই অর্ডার হবে, সেম অর্ডার। না 62 পর্যন্ত হবে না, সেম অর্ডার।
33,
33, I have
None
instruction.
appears for the petitioner, although the CSC Limited is represented through counsel. This is the second such occasion when none appears for the petitioners. WPA such and such is dismissed for default without any orders to cost. Interim order if any stands vacated.
Grateful, man.
thirty-four,
My lord, I appear for the CSC Limited.
For the CSC,
Yes, ma'am.
same order. Dismissed for default.
35 as well.
You are for the petitioner?
No, no, no.
thirty-five,
CSC.
Same order.
thirty-six,
অত করতে হবে না, দেখে নাও। আরে নেই তো পিটিশন, আর দড়ি খুলতে হবে না, কি দেখা যাচ্ছে। সেম অর্ডার, শুধু সিএসসির বদলে WBACDCL। Dismiss for default, Mr. Naik.
Grateful, sir.
37,
But I am for the response.
Same.
Last
WBACDCL, Mr.
Yes, last occasions also they did.
38,
My lord, CSC. is fine.
CS. Yes, move the matter, Mr. Aditya.
I don't know what the matter, but I lost my place.
No, if you appear, I'll give you time. If you want time, I'll give you time. If nobody appears, then I presume that nobody is, the client is also not. Please go through the records and take instruction. I'll keep it next week then. I'll record an adjournment is sought by you.
My lord, even we will need to reconstruct our records. It's an old matter, my lord.
Let
We
us
need
see whether his client is willing anymore to press the matter. On the prayer of learned counsel for the parties, I'm making both sides then. Learned counsel for the parties, the matter is adjourned till May 15, 2023. 2 weeks.
Grateful, my lord.
Thank you, sir.
39.
Yes, 39. None appears second time. This is for default. Oh, yeah, order. None appears for the parties.
Item 40.
Same to same parties.
Forty-one.
We are the respondents in this matter.
Acha. You're for the WBACDCL?
Yes, yes, yes.
ওই সেম পিটিশনার আছে ডিসমিস অর ডিফল্ট পিটিশনার নেই WBACDCL is there.
Forty-two.
But I am for the
Respondent same.
Forty-three.
None appears for the parties. This is for default.
Forty-five.
WBRC
44.
44 lordship.
44 কি হলো?
44, I'm not there.
44 you are appearing, both of you.
No,
No, I'm in 44, I am appearing lordship.
44 ওই petitioner absent WBACDCL second occasion dismiss for default.
Obviously, lordship.
Grateful.
এই তন্ময় তুমি সিএসসি লিমিটেড বা WBACDCL যেগুলো বলছি লাইসেন্সিও করে দিতে পারো তাহলে এক কমন অর্ডার হবে।
45.
Item number 45 and 46, both,
You're for
DVC man.
both respondents.
both WBERC
No.
and DVC.
None appears for the petitioners, although the WBERC and the DVC are represented through counsel. Dismiss for default without an authorized cost, interim order if any vacated.
Forty-six.
Same.
16.
You are not in this matter.
No.
এখানে petitioner absent. You are for DVC in this matter? No. আচ্ছা WBERC তাহলে এটা শুধু present. Petitioner absent, WBERC present. This is for default without any orders to cost, interim order vacated.
47.
My lord, I appear for the respondent in the matter. My lord, on the last occasion, the petitioners had sought for time to file supplementary affidavit and the extension was also granted. My lord, we have not received any supplementary affidavit so far.
You are for the
Petitioner, my lord.
what is the supplementary affidavit?
My lord, in this matter, the Tilak Kumar Bose is the senior. He is not present today, my lord. I am praying for not.
Not
today.
present in court.
I have instructed in that way. I don't know.
Probably wrongly instructed.
Okay, well, he cannot be present today. So he's praying for not today.
Don't say that in court. You say
Okay.
that he's stuck up before some other court or on his legs or whatever else. Don't say he's not present in court. That
Apologies,
has
my
a
lord.
different connotation and unnecessarily you are a junior advocate, you will be marked.
Apologies, my lord.
An adjournment is sought for the petitioners, full stop learned counsel for the respondent DPSC Limited submits that no copy of the supplementary affidavit directed to be filed by the petitioners has been served as yet on the respondent, full stop. As a last chance to the petitioner, the time for filing supplementary affidavit is extended for a week from date. Full stop, an advance copy thereof shall be served on the learned advocate for the DPSC for the respondents in the meantime. The matter shall be listed next on May 8, 2020.
My lord, I did not want to interrupt. My lord, I'm still waiting on instructions from the client. It's a 2012 matter. They are still trying to.
8th, I'll keep it on 8th. 8th, come back on 8th. Take instruction.
Grateful, my lord.
Grateful, my lord.
My lord, taking item number 44, my lord.
Whatever happened, happened. You're for the petitioner?
Yes, my lord.
Dismiss for default. All matters, old matters, dismiss for default.
My lord, actually, my lord, this is old matter, my lord. I could not contact with the client, my lord. But kindly pick.
If you said that, I would have granted adjournment, but I have dismissed it in open court.
I was
Now,
running.
definitely not. You'll have to file a restoration application. colony. Other side was also present probably in some of the cases.
48,
None appears for the parties. Second occasion, dismissed for default. Ah.
49 and 50.
49 people, Lordship, we have been led by Mr. Ananda managing this matter. On the last occasion, we were directed to file notes of arguments on the basis of which the arguments can be conducted. I'm praying for a short date in this matter. Any day after 10th.
Short.
Any date convenient to your Lordship.
Previously also time was granted to you.
Right, to file the notes of arguments.
Yes.
We'll be filing the notes of arguments in the due course before the next day, your Lordship.
Question of virus of 126 and 127 are involved in the matter.
No, they have to consider the subsequent judgment which has come was. On the prayer of the petitioner, the matter is adjourned till May 10, 2023.
I'm grateful, your Lordship.
Okay.
51,
None appears for the parties. Second occasion, dismissed for default.
$52,
Same.
$53,
Same. None appears for the parties. Dismissed for default. Sub second occasion এগুলো।
54,
Second. আগের বার কেউ অ্যাপিয়ার করেনি? খুলতে হবে না, খুলতে হবে। দুই দাও। হ্যাঁ, same.
$55,
Amendment application was directed to be filed by the petitioner on the last occasion when the matter was called on for hearing. However, no such application appears when the matter is called on for hearing, nor do any of the parties represent themselves when the matter is called on for hearing. Accordingly, let the matter stand adjourned till May 8, 2023. যদি অ্যামেন্ডমেন্ট কিছু দেয় এর মধ্যে দিয়ে দিও, তাহলে পরের দিন এই অর্ডারটা দেখিয়ে দিও ওকে ডিসমিস করতে পারবো।
56,
None appears for the parties. Second occasion, dismiss for default. পুরো সেন্টেন্সটা করে দিও কিন্তু।
57,
সেম।
58,
একই। On the last occasion, the matter had been adjourned on the prayer of the petitioner. However, when the matter is called on today, none appears for the parties. As a last chance to the petitioner, let the matter stand adjourned for the day.
$59 and $60.
Your Lordship, in 59 and 60, I'm appearing for the plaintiff and I'm led by Mr. Shamal Chakra. He is not well and therefore I'm praying for an adjournment of 7 days, Your Lordship.
Can't hear you, Mr.
In the tower, they are having near about 120 towers in different parts of West Bengal. And my lord, on the last occasion, Mr. Sarkar was appearing. These two matters relates to my lord, theft of electrical energy and huge amounts are to be paid. Mr. Sarkar said that our company, they have my lord, formulated or constituted a high power, high level committee who are looking after the affairs of this, my lord, this Indus Towers cases, and perhaps it is already sorted out and resolved. Now, my lord was pleased to direct us also to take specific instruction. What is our case? Now, my lord, we have taken specific instruction on this. It is very clearly stated, yes, it is correct. High Court committee has been formulated to look after all of the outstanding position and other dues, not related to, my lord, theft of
It's
electricity.
an act, take written instruction on that. I'll give her 1 week's time since she's asking for time.
Yes,
Please
we
take
have taken
instruction.
written instructions.
Yes, I'll keep that on record on the next occasion, pass whatever orders. An adjournment is sought on the ground of absence of learned senior counsel appearing for the petitioner.
Yes, your lordship.
Petitioner, full stop. Accordingly, let the matter stand adjourned till May 8, 2023. 8th May.
Your lordship.
You are from his chamber. You are from his chamber.
Yes, your lordship.
Please inform Mr. Sarkar whenever he becomes fitter that this has happened. Regarding this dispute, there was no high-powered committee. High-powered committee was there,
yes,
but high-powered committee decided other matters. This dispute was not resolved by the high-powered committee.
Okay, your lordship.
Lordship, may I permit to mention item number 58, Lordship?
58, what happened?
Lordship, in this matter,
58, I passed an order.
yes, Lordship,
It will
Yes,
be tomorrow, taken up tomorrow.
taken up tomorrow.
61.
My lord, 61, I am for the respondents. My lord, any day after 8th, your lordships kindly fix the matter. Because I shall have to consider
You are
other.
for the petitioner.
This is a case, my lord,
I
where
have no objection. Kindly fix the matter. Kindly fix
Obviously,
the matter. It will be disposed of.
Very well. On the prayer of learned counsel for the petitioner, the matter is adjourned till May 10th. 10th May?
Yes.
grateful to you.
After 8th, you said?
Yes.
It's 10th May.
10th. সোমনাথ নেই সোমনাথ কোথায় গেছে
62.
Second occasion, none appears. Occasion, none appears for the parties. This is for default without any orders. Interim order stands vacated.
My lord, with apology, my lord, since your lordship.
Yes, Mr.
My lord, your lordship's pleasure was to direct the respondent number 4 to be present personally on the next date of hearing.
Rule will be issued. Rule has been issued.
16 rule has been issued. My lord, it was not within my knowledge that post nobody is functioning as on date because the previous earlier personnel is already retired. So, my lord, can it be petitioner number 2A? Yes, contempt number 2 or anybody. So that part is troubling me because
No, but you did not submit when it was.
yes, that was not within my knowledge. Now they have come with this instruction that this post is vacant. So, my lord, that will be another flouting of your lordship's solemn order. So,
Mr. Bajpayee, ask your learned junior to give a notice to the other side. This will appear as to be mentioned day after tomorrow.
day after tomorrow.
To be mentioned day after tomorrow. Or tomorrow it will appear as to be mentioned.
Yes.
But you have to give a notice to the other side.
Yes, yes, I will definitely, right now I will give a notice.
অরিত্র ম্যাটারটা কাল টু বি মেনশন দিও আজকে যে অর্ডার হয়েছে সেটা থাকবে কারণ দ্যাট হ্যাজ বিন পাসড ইন ওপেন কোর্ট প্রেজেন্স অফ দি আদার সাইড দ্যাট উইল বি দেয়ার I'll if necessary I'll recall that order or modify that order tomorrow but give a notice to the other side. It will appear as to be mentioned tomorrow for passing further.
Yes, yes, definitely, my lord, don't take me amiss.
For that, no.
But and I learned that your lordship has recorded that no one.
That yes, Mr. This was absolutely against decorum.
Unethical.
No,
But-
not on you. You were there. You asked for leave of court to leave.
Yes.
But the other person with you did not. When the order was being passed, when I looked at that at your chairs, there was nobody appearing for the contemners. And I was issuing a rule of contempt, Mr. Bajpayee.
Yes.
This was patently unfair to the court, to the judicial system. That's why I've recorded only. I have not issued a rule of contempt against the advocate, but I've stated that the advocate was not there, although the senior counsel prayed for time and liberty was given, but subsequently all left and a contempt rule was being issued. If it was an ordinary matter, Mr. Bajpayee, definitely I would not have recorded that in my order. I have not passed anything penal, but that should be in the order. That should be for posterity, for them to know what should not be the conduct of a learned advocate. Yes, yes, absolutely there.
That part, your
That
lordship's
part will remain, Mr. Vajpayee. No, you are
and-
not present, you cannot cure that. You are not present, you took leave from me.
Yes.
And I granted you leave,
Yes,
Mr. Vajpayee.
my lord.
But nobody was there when the rule was being issued, which is absolutely beyond decorum.
Yes.
During
definitely.
the midst of argument,
Yes.
all of you left.
My lord, I am with your
That
lordship.
is not,
lord.
Mr.
That
Vajpayee, we have learned this from you people,
Yes.
you seniors.
Yes.
And now you are asking me to flout it.
No, I am not asking to flout it.
No, that decorum should be there, Mr. Vajpayee. There should be some matter of sanity in court.
Yes.
Some matter. I'm not over strict, not over technical, but these are basic cultures.
Yes,
We
definitely.
should know them.
My lord. As your lordship thinks fit.
This
my
is
lord.
not a personal thing at all.
No, no.
Not any against anybody.
Ye-
I may have a very good relation with you, with Mr. Chatterjee, no difficulty. But if you do this in court, I'll have to do this from
Yes,
sitting
yes,
from here.
yes. No,
Even if it's my own relative,
My
I'll
lord.
have to do this from here.
Yes.
That's my job. I'm paid for that. So I'll do this again if it happens. Call on the next matter.
But at the same time, my lord, lordship kindly forgive us.
No question of taking anything personally against anybody. Whatever happened in court, I passed already in open court and I've forgotten. You reminded me, that's why I recollected.
I hope
I don't remember anything which happens in court. Whatever happens, moment, done. This
I
is
hope you-
nothing personal, Mr. Vajpayee, I can assure you. I don't keep anything personal in
that
court.
I know. That I know, my lord. And
No, because this matter you may have an apprehension, but no, from now, Mr. Vajpayee, regarding these things, I don't carry anything beyond court, outside courtroom. Definitely not.
definitely.
There is no question of that. Whatever happens, I'll pass order in open court. Nothing behind your back, nothing behind my back, I hope.
Let us hope for change of mind of your lordship.
Thank you. Call on this.
Part had matter, item 63.
Yes, Mr.
And this
Chakravarti and Mr. Mr. Mukherjee was there. Mr. Agarwal, yes.
But
One of the issue is delay payment surcharge.
My lord was
Now the Honorable Chief Justice has scheduled this matter to appear on 27 June. But I am enjoying, my lord, you can remember this matter was, I had argued on the contract demand.
So adjourn sign it till that matter.
Yes, my lord, we are suffering, but there are other issues. my
I am
lord.
also suffering for these
My lord,
matters.
may I only say this, my lord, kindly, I want to file an application. I'm enjoying a stay of the delay payment surcharge.
Use the microphone, Mr. Chakravarti. What application?
My lord, I tell you, my lord, there is certain issues, my lord, thereafter, my lord, the company was closed for a long period of time.
When do you intend to do that?
My lord, within a week, my lord.
I'll keep it 2 weeks after.
Yes,
File
ma'am.
that application, give them copy.
Well, at least on the delayed payment surcharge, my lord, if it's a new cause of action, my lord.
But it is in connection with the.
I can always reject his application after
Yes,
hearing you.
don't worry.
They are not precluded from filing an application.
no,
sir.
not
I cannot do that.
No,
But I can reject their application if there is no cause of action.
Yeah, I'm grateful, man.
Even if Mr. Chakravarti appears and says grateful.
Well, let
Even
the application appear in its ordinary course, my lord. That is the reason. But
it is appearing in its due course.
No, no,
Why
the
order?
application which they will file.
You are trying to play smart, Mr.
No, my lord, I'm
Not so smart. Don't be
I'm
so
extremely
smart.
sorry, ma'am.
You are smart. I appreciate that. Don't
I'm
be so
extremely
smart.
sorry, ma'am.
Learned counsel for the petitioners seeks an adjournment to enable the petitioners to file an application. First up, accordingly, let the matter stand adjourned till May 15, 2023. First up, such application, if any, shall be filed in the meantime, and a copy thereof shall be served on the learned advocates appearing for the DVC.
I'm grateful.
Deeply obliged.
কিন্তু 25 তো সেটা দেখো সেটা হলে উঠবো আবার আচ্ছা তাহলে একবার উঠে গিয়ে তাহলে 3:25 বসবো একবার আমি উঠবো এরপরে কি আছে হিয়ারিং ম্যাটার Before taking up the hearing, Mr. Paja, I have a division bench at 3:25. I'll rise once now and I'll sit with in the division bench at 3:25. I'll be resuming my matters from 3:30 because that will take 5 minutes or 2 minutes even.
My lord, in this matter, I'm praying for an accommodation.
Which matter? You will be taking time in the next matter. তাহলে next call করে দাও যেগুলো time নেবে দিয়ে দিই।
For hearing 64.
Adjournment, you are for the?
I'm for the petition. I'm led by Mr. Siddhartha Banerjee, my lord.
Till when? Mr. Siddhartha Banerjee is seeking time every day.
Yeah.
What is happening?
My lord,
You come ready in the matter then. Why every day?
My lord, kindly allow us.
I don't understand your gesture.
My
Why
lord,
is he asking for time?
Lord, he's engaged in court number 1, my lord.
No, no. This is the last chance I'm giving to him. An adjournment is sought on the ground of learned counsel for the petitioner. First up, it is seen that আগেও এটা টাইম হচ্ছে না দেখি it is seen that the matter is repeatedly being adjourned at the behest of the petitioner. So as a last chance to the petitioner to move the matter, the same is adjourned for the day. ডেকে নাও, যদি কেউ ধরার মতো হয় তাহলে আমি লিভ নিয়ে 10 মিনিট পরে আসবো। ওকে, ডেকে নাও।
65. 65. I will be paying for not today, Manoj.
Not today. You're for the petitioner?
Yes, Manoj.
I appear for.
On the prayer of the petitioner, Tanwa, on the prayer of the petitioner, matter is adjourned for the day.
Grateful.
Obliged to lordship.
66.
66.
But in the matter, I appear for WBCDCL, my lord, in the 65 lordship. Petitioner.
Yes, I know. 66 who is appearing?
Grateful.
Not today, Kuroda. Kono order record করতে হবে। I'll come back in 10 minutes.
From item number
No.
my lord, from item number 68.
Yes.
This matters are, my lord, second tariff order, the first tariff order, the appeal has been admitted, interim orders have been passed. So my this has
Adjournment.
to. Yes, this has to be adjourned, my lord.
Till when? Board এ দেখো।
68 to 90. 68 to 90, my lord. June রাখো। June না জুলাইতে? জুলাইতে রাখি। June ওটা
67 who is appearing?
67. Mr. Rahul Kormakar is appearing for the petition in
7 দেখো, vote.
Your lordship, in this matter in 67, I am appearing for WBS. I am led by Mr. Pratik Dhar, but his mother has passed away. This is very unfortunate. On
When
that
should I
ground.
keep it?
I am praying for adjournment.
When should I keep it?
Your lordship, we have to prepare the reply to the AO.
Prayer of the WBERC, the matter is adjourned till May 16, 2020.
May 16, your lordship, we have to prepare the AO, reply to the AO that they have served us.
Whatever you have to prepare in the meeting.
Kindly, if your lordship can kindly fix it on in the month list of June. If
Why?
Because they
for the petitioner. Who is? You have any objection then? Otherwise I'll fix it. Very well. তাহলে এটা কেটে দাও আগের লাইনটা। An adjournment is sought by the WBERC on the prayer of the said respondent. The matter is adjourned and shall next be listed in the monthly list of June 2023. 68 to 90 দেখিয়ে দাও বোর্ডে।
68 to 90.
My lord, it may appear in the monthly list of July, ma'am.
Very well. On the prayer of learned counsel for the parties, the matters are adjourned and shall be listed together in the monthly list of June 2023. Full stop.
July, my lord. July.
Sorry, July. Why July?
Well, June, the matters have been fixed.
Oh, acha. Monthly list of July tale gora. Why did then July then adjourn sign it? My list
My
will
lord,
be clear.
I do not have, the DVC is objecting.
My lord will kindly keep it on July, my lord, because the appeal court, my lord, we are suffering also, my lord, there because of that particular fact, my lord,
She's
knows.
suffering.
My lord, that licensee is the crores money is getting completely drowned, my lord. It's because of the fact of, my lord, appreciates the fact, my lord.
July monthly.
July monthly.
Next
I
matter, I'll be
am
calling.
for the WBS, your lordship.
Give your names. No, 91. I'll come back and sit in the division bench at 325 then.
Not to the
দেখো, দেখে দাও।
91.
তো লিস্টে শেষ হয়ে যাবে গো। কটা আছে টোটাল? 101। লিস্ট হয়ে এটা কেন তো? ছেড়ে দাও।
91.
একটু দেখি স্যার।
But I am for the. লিস্টটাই তো শেষ হয়ে যাবে আর হ্যাঁ।
নট টুডে করে দাও, কিছু অর্ডার রেকর্ড করতে হবে। নট টুডে।
92.
92, my lord, I am for the respondents, my lord.
Madhav Babu, none appears for the petitioner. Respondent is represented through counsel, adjourned for the day.
Grateful to you.
না আমি ফিরে এসে নেবো, 3:25 বেঞ্চটা আছে। I'll come back after 325. 325 I'll be taking a division bench, 2-minute matter, then I'll
Deeply obliged, my lord.
இப்போ ஆஃப் பண்ணிடுங்க. இது வந்து அவங்க கண்ட்ரோல்ல இருக்கு. வீடியோ வந்து கண்ட்ரோல்ல இருக்கு. அது அனுப்பிச்சு
Item number 1.
My lord, I am appearing for the petitioner, my lord.
I appear for the alleged contemnants, my lord. My video has been disabled, my lord. If the person can enable my video, otherwise my colleague Mr. Agarwal is also present in court, my lord.
Yes, my lord.
Video has been disabled.
Yes, my lord. The host has disabled my video, my lord.
Please check up.
It says host has disabled video.
Yes, we're trying to rectify that.
Yes, my lord. Now it is okay.
Very well. Yes.
My lord, kindly
Yes.
come to page number 21, my lord.
Did we direct affidavits in this matter?
No, my lord. No, my lord.
So what is
My
your
lord, my instructions are that the order has been complied, my lord. The order is, Mr. Agarwal is in court, he'll hand over the order.
My lord, my lord.
Although there was some delay in compliance,
My
but
lord,
it has
my
been
lord, my lord.
complied.
My lord, let me place the order, my lord.
Mr. Kumar, please do. Please.
My lord, kindly come to page 21, my lord.
Mr. Agarwal, take your seat. Yes. 21.
My lord.
Yes.
My lord, this is a judgment passed by my lords on 27th of July 2022, my lord.
Right.
Now, my lord, kindly come to page number 36, my lord. Running page, my lord. Internal running page 36, internal page 16 of the judgment, my lord. Kindly come to paragraph number 43, my lord.
Yes.
My lord, this court therefore holds that the original applicant writ petitioner in WPCT number so and so would be entitled to continue in their respective posts till they are replaced by regular selected candidates. For the reason as aforesaid, the impugned order is modified only to the extent that the original applicant shall be allowed to continue in their respective posts, and the administration is directed to extend the period of contract of appointment and or the renewal the same with effect from the date of expiry of the last extension on the same terms and conditions on which they were engaged till they are replaced by regular selected candidates. However, the original applicant shall not be entitled to any remuneration for the interim period if they are not rendered any service during such period. An opportunity of hearing is to be afforded to the original applicant by the administration before taking any decision that the original applicants or any of them are not entitled to remuneration for any such period. Now, my lord, after this order, my lord, I communicated this order at page 38, my lord will find on 28th of July 2022, my lord. Thereafter, my lord, I have sent a reminder on 10th of August 2022, my lord. Now, thereafter, in the month of November, I took out a contempt application before this honorable court, my lord. After I filed the contempt application, my lord, on 6th December 2022, my lord, in compliance to the said order, my lord, their contract period was extended, my lord, from 1st May 2022. My lord, that order is not with my lords. Perhaps Mr. Agarwal is having
Yes, Mr. Agarwal will just pass the copy of the order.
My lord, it was extended. If my lord kindly have a note of it, my lord, kindly.
Is that Mr. Chakraborty?
Yes, my lord, he's.
He has changed his appearance, my lord.
Yes, my lord.
Entirely.
He may be able to explain it better, my lord.
So that will be the next contempt. Beautiful face, why? Foliage. Anyway, yes, Mr. Kumar, yes.
My lord. Mr. Agarwal has handed over the order, my lord.
Yes, handed over. So that was done, they're saying.
My lord, that was done on 6th December 2022, my lord, having effect from 1st of May 2022 to 30th April 2023. What I am on, my lord, the scope is very limited, my lord. My lord, July, my lords have passed the order. My lord, the intent of the order was to immediately go for continuation of the said order because they are working from more than 10 odd years, my lord. Now they took 5-month time, my lord. We were ready to discharge our duties, my lord. When I taken out the contempt petition, my lord, subsequently this order was followed. So what I am on, my lord, after the order of my lords, my lord, I am entitled for the wages for the said 4 month, my lord. I have been debarred by them Admittedly, they have not challenged this order before any court of law, my lord. Rest I leave up to this honorable court, my lord.
Which are the 4 months, Mr. Kumar?
My lord, after my lord's judgment, my lord,
Yes.
that was rendered in the month of 27 July 2022, my lord. I
Right.
communicated on 28th of July, followed by reminder on 10th of August. Thereafter, I taken out the contempt application. After filing the contempt application, my lord, the order was complied. From a subsequent, from December, my lord. So last 4 months, August, September, October, November, we were ready to discharge our duties, but they did not allow us. Though the contract period was extended from 1st May 2022.
So let us hear Mr. Chakraborty on that. Yes, Mr. Chakraborty, on that, these 4 months, that is a limited scope.
My lords, the order says that they will not be paid between 1st May 2022 till till the date they reported for duty. Now, my lords, the only thing is that, my lords, they can fresh cause of action, my lords, for that purpose. If they, otherwise, my lords may pass orders, my lords, contempt proceeding. My lords, I am only saying that as your lordship deems fit, but ordinarily, my lords, I would think that this would give rise to fresh cause of action so far as the money for the period where they are saying they were busy for report, they were available, but because there was delay in compliance. Otherwise, my lords may direct, my lords, as your lordship deems fit, my. Because my lords will see in your lordship's order, there is a specific finding that they will not be paid for the period during which they have not worked. So, my lords, there might be some kind of, because of that, had it been a case if lordship had directed that they'll be paid for the entire duration when their services were not availed, then it would have naturally flowed from the order. But in a situation where lordships have specifically held that they will not be paid for the period when they haven't worked, now in the contempt jurisdiction, whether, my lords, they should be entitled to this period.
Factual question may arise as to whether they actually intended to join or not. These things probably.
Yes, my lord.
Yes,
Let
Mr.
them file an
That is a
affidavit,
difficult.
Mr. Chakraborty, I'll direct you to file an affidavit in this.
my lord. My lord.
So, if they had intended, but you did not permit them to join, then probably we'll pass that order. I mean, I'll direct you.
We'll do that.
Mr. Chakraborty.
My lord. My lord. My lord.
The limited grievance of the petitioner in the contempt application is that despite this court having passed an order on July 27, 2022, inter alia allowing the petitioners to continue in their respective posts and directing the administration to extend the period of contract of appointment and or to renew the same with effect from the date of expiry of the last extension on the same terms and conditions on which they were engaged till they were replaced by regularly selected candidates, the alleged contemners have only given effect to such order subsequent to the filing of the contempt application, that is in about December 2022. Full-stop, it is submitted that the petitioners were entitled to the wages for the intervening 4 months, since they were willing to join but were not permitted to do so by the administration. Full-stop, next para, learned counsel appearing for the alleged contemners submits that in the event the petitioners have such a grievance, it would be for the petitioners to file a fresh writ petition on such subsequent cause of action. Full-stop, the same does not come within the purview of the contempt jurisdiction of this court. Full-stop, that apart, learned counsel for the alleged contemners submits that the specific direction of the court was that the original applicants shall not be entitled to any remuneration for the interregnum period if they have not rendered any service during such period. Full-stop, such observation, it is submitted, did not entitle the petitioners to claim the wages for the period during which service was not rendered. Full-stop, next para, be that as it may, it is required to be established by the petitioners that the petitioners sought to join service, which was not permitted to be done by the respondent authorities during the relevant period, comma, in order to bring the matter within the jurisdiction of the contempt court, full stop. Since factual aspects have been pleaded, comma, the alleged contemners stroke respondents are directed to file their affidavit in opposition. How soon can you file an affidavit, Mr. Chakraborty?
My lords, whatever your lords, as your lordship deems fit, my lords.
We'll give you till 18th May, the 19th May, the day before closing, 18 days.
My lord, my lord.
Their affidavits in opposition by May 19, 2023, full stop. Reply, if any, shall be filed by June 9, 2023, full stop. The matter shall be listed after the period of filing of affidavits is over. We are not fixing the specific date. Tentatively, it will be on 12th June, but we'll be informing you date and time because we have different benches. So we'll have to take care of that and we'll inform you. Very good. Thank you. Mr. Chakraborty, you have kept it vague. Just ascertain whether they could not join because they were not allowed to or whatever. I mean, or they chose not to join.
My lord.
Please file in your affidavit you just disclose. We'll just direct pay those 4 months wages probably.
My lord, my lord, my lord. Yes, ma'am.
Thank
you.
Grateful.
Item 2.
My lord, I am appearing for the petitioner, my lord.
Yes.
Here, my lord, a disciplinary proceeding was initiated against the petitioner, my lord. And the disciplinary authority held guilty of charges. Appellate authority affirmed it. Challenging the said, he filed a original application before the tribunal. Tribunal held the charges are not proved and set aside the order of the disciplinary authority and appellate authority, and thereafter remanded back the matter to the disciplinary authority for passing necessary orders. Challenging the same, my lord, they preferred writ petition, and my lords has heard the matter, and my lord, and on 29th of July 2022, my lords passed the order, my lord. If my lords come to page number 36.
What is the internal?
36, my lord.
Have you served copy? Did we direct you?
No direction was there, though my lord, when the matter was filed, then they appeared, my lord. Somebody appeared in the circuit bench, my lord. When
No, the contempt application we
the
have
matter was directed to place before VC, through VC, my lord. My lord.
So serve copies on them. Have you served?
My lord, service was affected, perhaps, my lord. My lord, somebody is appearing from the, I have seen from the our circuit bench, my lord. VC room.
Responded to
For the contemptor, my lord.
Oh, what is your stand in the matter?
My lord, there is no contempt at all, my lord. The order of the court has been duly complied with.
Mr. Kumar, in this matter also will direct affidavits and let them say what they have to.
My lord. My lord.
File an affidavit in opposition within 19th of May.
We have filed, my lord. Affidavit in opposition has also been filed.
No, sir, copy was served.
All right, my lord. We will call. Service will be affected, my lord.
We have not yet filed.
My lord, I have not received any copy, my lord.
We will file, yes.
My lord, we will file.
Since certain questions raised in the contempt application has been denied on fact, and it is submitted on behalf of the alleged contenders that the order of this court has been complied with, comma, the respondents stroke alleged contenders are directed to file their affidavits in opposition by May 19, 2023. For sub reply, if any, shall be filed by June 9, 2023. For sub, the matter shall be listed for hearing thereafter. This matter also, tentatively on 12th, it will appear, but we'll inform you both of you that.
My lord, the opposition is already filed by us in the registry, but in February itself.
Nothing has come here. Please ensure if that is there already, then please ensure that
No, but my lord, in that event also no copy was supplied upon me.
My lord, we will serve the copy.
directions be, yes, let the directions be as it is. Yes.
My lord.
We'll take up both the matters together, Mr. Kumar, so it will be easier for all of us.
My lord, my lord, my lord, oblige. my lord.
We will resume Kobu Singh.
Deep level. So, Mr.
Ninety-three.
93.
Your Lordship, I am for the petitioner in this matter.
Yes.
Your
Right,
Lordship,
on behalf of the WPSCPC, where there was a direction for filing affidavit.
Use the mic, Mr. Mukherjee.
There was a direction for filing affidavit, my lord. But I have given affirmed the copy and have been served on time. May I, my lord, hand over a copy?
Where is the reply?
Your Lordship, I was seeking some time to file the reply.
How much time? Tell me.
2 weeks' time, by 15th May, it could be granted, and
You're not enjoying anything in interim order.
Your Lordship,
They are.
regarding that, Your Lordship, page 3 of the order of Your Lordship,
Yes.
there is an order passed on 17th of February 2023, Your Lordship. On Your Lordship, an order was granted in favor of us on 8th of February 2023, page 2 of the order. It is seen that the order dated 2nd February 2023, the learned single judge, that the ground on which the interim order was granted, thereby injuncting it from invoking the bank guarantee. Your Lordship, page 3, Your Lordship directed the third paragraph, IA Can 1 of 23 is accordingly disposed of, directing WESCDCL to encash the bank drafts obtained by the WESCDL upon invoking the bank guarantee which had been furnished by the present petitioners. Out of such encashed amount, an amount of rupees 88,14,407 shall be appropriated by them in view of the same being an admitted outstanding due to as per the writ petition itself. And the remaining, Your Lordship, was to be given back to us so that we could issue a fresh bank guarantee. However, in the fourth paragraph, Your Lordship, it is stated that we had mentioned the matter as well, Your Lordship, thrice, if for clarification. As regards to the balance amount obtained upon such encashment, the said amount will be returned to the petitioner, subject to the petitioners executing a fresh bank guarantee for equivalent amount within a period of fortnight from the date of receipt of the amount of rupees 88. Upon such bank guarantee being executed by the petitioners, the WBCL shall return its cash equivalent to the petitioner within 48 hours therefrom. Your Lordship, we've not been given back the refund, Your Lordship, of the remaining amount of 21,21085,593. Your Lordship, because there is some, because they are stating, because we have to execute a fresh bank guarantee, thereafter 88,000 they'll deduct, and so if they could refund that money and thereafter, because we do not have so much of liquid money, Your Lordship, to encash amount of.
No, it will be subject to the order was very clear. There is no clarification required. Said amount will be returned to the petitioner subject to you executing a fresh bank guarantee.
Your
You have to
Lordship,
execute
my
the bank guarantee.
entire money is with them, Your Lordship. So unless they refund my money, Your Lordship, they can take back 88 and I will execute on the same day itself. Within 2 days, I'll execute a fresh bank guarantee, Your Lordship, because I do not have so much of liquid money. My mill has been closed for last.
File an application for modification, one line application, I would have done that.
Your Lordship, I had mentioned thrice this matter
Mentioning
before
won't
Your
do.
Lordship.
Verbal mentioning won't do.
Your Lordship, I'll file
You
a.
have to tell on oath, you have to avert those facts.
I had advised the client the same, but my senior, Mr. Shomo Majumdar, he said, do not file a clarification, just mention before the court. The court will allow, because this is just.
If it was a current matter, I would have. But now, after so many days, no.
Your Lordship, on 27th of February, this order was passed on 17th. I had mentioned on 27th. Your Lordship directed it to appear as to be mentioned.
I'll extend the time for filing reply.
It has already been expired on 17th of April subsequent to your lordship's order dated 3rd of April.
Your Lordship,
We have
because we are
served them on
challenging
5th.
a virus.
And one more thing, she's saying for mentioning, we have not been served with
We
any
had
notice.
issued a notice, Your Lordship, through email. The notice was issued that it would be appearing on 28th. Your Lordship directed twice this matter was mentioned, Your Lordship. On 28th itself, Your Lordship had directed the matter to appear. I have the mentionings email as well, Your Lordship, by which I had served them.
28th of?
28th of February.
No, I'll give you 1 week's time extension.
Your
1
Lordship.
week.
Well, Your Lordship.
The petitioner seeks 2 weeks' time to file the affidavit in reply. Full stop. It is seen from the records that previously directions were already given for exchange of affidavits. Full stop. The affidavit in opposition filed by the WBSCDCL today be kept on record. Full stop. Since the petitioners could not comply with a part of the direction given in the order dated February 17, 2023,
April 3rd,
on
2023.
certain grounds which the petitioners plead were beyond their control, as a last chance to the petitioners, the time for filing affidavit in reply is extended till May 8, 2023. First of the matter shall be listed on May 10, 2023 for hearing.
Obliged, Your Lordship.
Till 8th May, Mr. Mukherjee, they'll file your reply. I'll take up the main writ petition and I'll discuss.
Your Lordship.
I'm grateful.
This is an assigned matter.
Your Lordship, this is, Your Lordship had the determination that Your Lordship was not sitting when the urgency had.
Initially moved before Justice
Moushumi
So do I have determination now?
Yes,
Your Lordship.
The electricity matter.
Electricity.
94.
Obliged.
I am for the electricity company.
Yes.
If your lordship kindly see the last order, there is a specific 2 direction, one upon me and another upon the petitioner. One direction that I have to comply with that order, that the payment of consolidated amount of rupees 50,000 in pursuance to your lordship directions within 7 days we have already paid, my lordship. And there is another direction upon the petitioner to add the private, that is the owner of the house, to be as a party. It is a case of a compensations, electrocution. Then your lordship on the last occasion was pleased to direct the.
Dr. Shara, can you ensure that a notice is given to your other side? I'll record this and I'll direct you to give a notice. I'll keep it on, say, day after tomorrow. They have been appearing all along.
But kindly keep it up. I will.
Inform them. When should I keep it? Tell me. Tomorrow?
Tomorrow is a very short time. I
Very
don't know
short
whether
time.
they are.
I'll keep it on Thursday.
Thursday
or Wednesday, whenever you see.
As your lordship, please.
I'll keep it on Thursday. Learned counsel for the WBSCDCL hands over photocopies of an office order dated April 24, 2023, indicating that the WBSCDCL has complied with the direction of this court dated April 20, 2023.
Payment made on 27/4/2023. In the next page, your lordship will find that.
Showing that payment has since been made on humanitarian grounds of the amount of rupees 50,000 as per such direction. Full stop. However, since none appears for the petitioner, the matter is adjourned till May 4, 2023. Full stop. The learned advocate on record for the petition for the WBSCDCL is requested to serve a notice on his counterpart appearing for the petitioner, indicating the next returnable date. If they choose not to appear after getting the 50,000, then I can pass further orders.
Lordship. $95.
Lordship, I appear for the petitioner, my lord.
Yes.
Pursuant to your lordship's last direction, my lord, I would be requiring a further 1 week's time, my lord, for filing the reply, my lord.
This is that matter, my lord, where the prepaid meter is the issue, whether, my lord, prepaid meter can be given to a high voltage consumer. May I hand up, Lord, the affidavit in opposition?
Yes.
This is nothing to do with the merit of the matter. These are all regulations which are annexed.
The affidavit in opposition filed today be kept on record. On the prayer of the petitioners, the time for filing reply is extended till May 8th, 2023. First up, the matter shall be listed next on May 10, 2023.
Instead of 10, could it be 11th? Lord?
Yes. তাহলে May 10 না করে May 11th.
Lordship, I'm
Much
grateful.
Thank
you. 96.
I'm for the CSC. I'm for the petitioner, my lord. Lord, I'm extremely sorry, my lord. Lord, the papers are not with me, my lord, today. Lord, the old building of Delta House, they have closed the building today because of 1st May, my lord.
On the
Papers
prayer
are
of the
with-
petitioners, the matter is adjourned. On the prayer of the petitioner, the matter is adjourned for the day.
Yes. Much
Record the
obliged.
name. sir. Thank you.
Assigned matter. Item 97.
That's my writ petition. My lord, before my lord, your lordship takes up the writ petition, my lord, there is a CAN application pending for amendment, my lord, of the writ. My lordship, will kindly take up that amendment application first, my lord.
Lordship, I appear for the respondent number 3, my lord. If your lordship will kindly pass it over for only, then lordship
On
will
the prayer
kindly
of the
take it
respondent number 3, the matter is.
Only one thing, my lord, in that event, the sword that is hanging over my head also should be removed, my lord.
What is the sword?
The sword is, my lord, that if my lord, on the last occasion, my lord, nobody appeared for the petitioner, there's an observation of your lordship that.
No, I'll record on their prayer. This is.
I mean, that sword.
I'll go on alternatively giving last chances to both of you.
Lordship will kindly take it up tomorrow, my lord.
Just
কোনো অসুবিধা নেই।
amendment application, you oppose করবে কি? You don't have.
No, no, don't get swayed by this. It's a innocuous, innocent face. Don't. On the prayer of the respondent number 3, the matter is adjourned for the
Lordship,
day
kindly fix a date in that event. Then
Yes, your lordship.
tomorrow
Tomorrow, lordship.
and will be taken up next tomorrow.
daily list is that.
Daily
It will have to be. No, I'll indicate something in the list.
Ah,
The comment list is getting over.
So that's why, my lord, let it appear in the daily list in that event, my lord. It will
Take care of that. Some indication will be there that this will be taken up tomorrow.
Lordship.
और तो ताई कर दियो কালকে इससे पर इंडिकेशन दे दियो যেটা चलो next.
Obliged to you.
Thank you.
Much.
Thank you.
98.
Not required.
$99.
Not today.
100.
My lord, I'm for the respondent, private respondent, that is that application for
My lord,
Sapurji Colony I'm appearing for.
Application for?
Whether the petition is maintainable or not. That
Achha.
is in the spirit of private respondents, that was Sapurji Colony I was appearing under the, and your lordship granted it to try my luck before the appeal court. And the appeal court, now both the appeals are, HITCO has also filed an appeal and Sapurji also filed.
Very
an
good.
appeal.
Yes.
And both the appeals are in the list before the court number 1. So your lordship kindly.
So should I adjourn it?
My lord, I'm praying for not today, my lord.
Why not today? Then when should I adjourn? Tell me. After the vacation, I'll keep it.
Lordship, as your lordship.
An appeal has been preferred against what?
Against maintainability, point of maintainability.
I held it is maintainable. Very good. Learned counsel appearing for the respondent number?
My lord.
Private respondent.
Private respondent 8, 9 and 10.
Learned counsel appearing for the private respondents hands over a printout of a server copy of an order dated April 13, 2023 of the division bench in an appeal preferred against the order whereby this court had held that the writ petition is maintainable. Full stop. Next para. In view of the pendency of such matter before the appellate bench and the same having been made returnable on April 27, 2023, the present writ petition stands adjourned and shall next be listed in the monthly list of June 2023.
Lordship.
Thank you. এটা একটু রেকর্ডে রেখে দিই।
101.
Not today. আর কিছু ডাকবো? বলে যাওয়ার ইচ্ছে নেই। রাম কি বলে যাওয়ার ইচ্ছে নেই। শেষ হয়ে গেলে ভালো জিনিস